Good morning, everyone. Just going to start in another minute or two. We still see participants that are joining the meeting. So in a minute, about 5 after, we will get started. Thank you, everybody, for your patience. Again, just letting everyone know, we will start in about a minute. We still have attendees that are joining the session. Oh, I got to turn on my... Good morning, everyone. We're going to start in about a minute. We are waiting for participants to come into the session. So in about a minute, we are going to start. Thank you very much, everyone, for your patience. All right. Good morning, everyone, and welcome to the LexisNexis Intellectual Property Solutions 2022 North America User Meeting. My name is Nick Valentino, and I will be your host for today's session. I lead our customer success team in North America, which has evolved and grown over the past couple years. Our team not only conducts onboarding product trainings and also solve technical support questions, but we also facilitate knowledge sharing activities as well. Examples of these activities that you may have seen are our monthly tips and tricks meetings that we host, where we go through common use cases or questions that our users are trying to solve. But we also facilitate knowledge sharing activities as well. Examples of these activities are also developing use case studies and also publishing industry ranking reports too. Sorry, everyone, seem to be maybe having a little bit of technical difficulties here. We're just doing a quick audio check. Can you hear? Just quick audio test here.
Rick said we can hear you. I've done something just now.
Okay, good. Thank you very much. I'm glad. Sorry about that. I will start over because I'm not quite sure how much of that audio came through. So sorry if you're hearing this again. But good morning, everybody, bright and early, and welcome to our LexisNexis IP Intellectual Property Solutions North America User Group meeting for 2022. My name is Nick Valentino. I may have met some of you already, but if not, just to let you know, I am going to be our host for today, and I also lead our customer success team here in North America. Our customer success team in North America has really grown over the past couple of years. Our team not only is involved in conducting product onboarding trainings, as well as solving everyday technical support questions, but we also are involved in facilitating knowledge sharing activities. Examples of these activities would be hosting monthly tips and tricks webinars. These are solving kind of everyday use cases or workflow processes, but also developing use case studies and publishing industry ranking reports. All of this is with the goal of providing additional services and promoting the sharing of information within our user community. The desire to hear how fellow users are responding to and solving everyday questions and challenges has been a theme that we've heard from as we've had discussions with our user community. So the point of today and the meeting we're hosting today is a direct result of that feedback. The goal of today's session is to give our customer community the opportunity to spread knowledge and share their best practices. So we are very excited about today's program. This has been a while in the planning for this year. I'm going to quickly go through the lineup that we have for today, as we have a lineup of power users who have graciously volunteered their time to share the ways that they leverage our tools to be successful in their day-to-day operations. And a lot of what these sessions are going to be are not just strictly how-tos. How do you generate a report, or how do you run a search? But more of it, it's going to be along the back ends of why is this information valuable? How do I leverage this information to be successful in my role? So with that being said, I'm going to quickly just kind of go through some of our speaking point, our presenters for today. Each session will be 30 minutes, and there is the ability in the Zoom webinar where you can submit Q&A to the panel. So there is time built into their sessions to ask them questions and receive responses. So kicking it off, we're going to have a mixture of not only the user presentations, but also members from our team as well within the LexisNexis IP team, where we'll talk about further tips and tricks and also product showcases as well too throughout the day. These sessions will be recorded and posted to our marketing page in the future. And one of the sessions that we're going to get today, so throughout the day, we're also going to have a contest as well, where you can all be involved. And that's where we'll view and vote on the weirdest patents. So this morning, we're going to have a couple sessions on prosecution data and how that can be leveraged not only to provide insights to your clients or to your corporation, but also how it can be leveraged for business development purposes. We will have a quick how-to on a common function in TotalPatent 1, where two of our tools can be integrated and speak to each other between TotalPatent 1 and PatentSight. And our senior director will go through a product showcase of our PatentSight product. In addition, we will also hear from additionally more insight into how corporations view the performance of outside counsel and tips on drafting applications as well. And as I mentioned, the audience participation with the weirdest patent, these were submissions from our user community. We'll do that later this afternoon, and we'll pick a winner. And we will round out the day having another product showcase on our prosecution tool, PatentAdvisor, and wrapping up on sustainability as a topic for today. So with that being said, our first session of the day that I'm going to kick it over to is a member of our leadership team. Marco Richter is going to be joining us from, we like to play this Where in the World is Marco right now, and I believe he is in Japan at the moment. He's going to be joining us to speak quickly on and briefly on address from our leadership team. Marco is very involved in our thought leadership a lot of the ranking reports and publications and webinars that we do to promote thought leadership. You will have seen him front and center on those. So we're very happy and glad to have him available from joining us from Japan to give us a quick little introduction to kick off the day. So Marco.
Hi, good morning, everyone, and thank you, Nick. And Nick, I need to clarify, I'm in Bonn, Germany today. I know my schedule lately is a little bit confusing. I just returned from the US after a trip to Japan, and I'm scheduled to go back to Japan as early as next Tuesday. So I'm in between countries.
Yeah, I lost the user pool then on where you were, so I'll have to rescind my choice there.
Yeah. So yeah, good morning again, everyone, and very excited also to welcome you here today. My name is Marco Richter, and I'm responsible for the Global Customer Success Organization at LexisNexis IP. And as I said earlier, I'm talking to you from Bonn, Germany, looking at the River Rhine just out there. As Nick has pointed out, we've been hearing from many of you over the past couple months and years an increased interest in sharing, but also learning from and with each other in the broader IP community around the different use cases.
Hey, sorry about the Gary was in the backstage, couldn't hear. Can you email him?
From others in the IP community. I'm sorry, Al, I could just hear you here on the recording. So this is the theme of sharing with others and learning from others that we've not only seen in the US, but also in other regions where we facilitated similar meetings over the years in Europe and across different APAC countries, predominantly also there in Japan. Thinking along these lines, I think it's actually really great that the IP community has always been so open and to share and learn. And it's at first glance a little bit counterintuitive because we're talking about intellectual property. But I've also learned quickly that while every company has certainly their own and secrets and ways to go about things, the practitioners are very open to share how they approach problems, what kind of use cases they're turning to when it comes to finding answers from an IP perspective, and how they tackle these problems. Of course, not sharing what the actual consequences and insights are, but I think it's really great that this openness exists in the space. Because there's another development that we've been hearing a lot about is the rise and importance of the intangibles becoming more and more important to companies. You've all seen these comparisons from the 1970s to just a few years ago, how the intangibles piece in a company's evaluation has been becoming the predominant factor for the portfolio valuation. And indeed, we now clearly see how the spotlight on intangibles has become stronger and stronger. Let me give you an example for that from Japan. So while I'm not in Japan today, we've been learning a lot from and with our customers over there. We're seeing now corporations in Japan disclosing more and more information on their patent portfolios, even holding public IP strategy briefings to their investors. This is driven by a change in the corporate governance code at the Tokyo Stock Exchange that asks corporates to disclose how their IP contributes to their business and how IP and business strategy are aligned in an understandable and measurable way. So with the investment community now increasingly becoming better educated on patent matters, we see an increased interest from institutional investors and financial advisories to leverage this information to make better investment decisions, but also turning to European and US-based companies to ask better educated questions with regards to IP and IP strategies. So now Sorry, somebody just muted me for a second. So we're seeing how European and American companies are now starting to react to these developments in Japan and in the investment community, where this information is increasingly being looked at. And they're starting to prepare their own briefing sessions on IP and IP strategy. So events like today, where we bring the community together, should embrace the learning and knowledge sharing in the community. And we see it as our active contribution to this community, as we acknowledge that this is a critical part of the role that we play here. We're on the one side developing and investing in our products and make them better and better based on the feedback that we get from all of you and from all the exciting use cases that you develop and uncover. But we also want to actively give back and invest into this community to allow for knowledge sharing and learning experiences in and around patent information. So I think that it's really great that today we'll be having presentations on our solutions around PatentAdvisor, PatentOptimizer, TotalPatent 1, and PatentSight directly from practitioners for practitioners from different viewpoints and angles. I'm very much looking forward to these presentations, and I'm very excited to once again learn more and more about what can be done with patent information. Thank you everyone for coming today, joining today's sessions, and looking forward to learn from and with you. Thank you. Back to you, Nick.
Thank you very much, Marco. I appreciate you kicking off the session there. And giving everyone just a groundwork, laying the foundation for our roles in organization and how important the customers are to us moving forward. So we are going to have our first session let me pull up the webinar, the agenda page here. And I will share my screen in a moment, everyone. What you can still do as of today is, if you haven't already, you can go ahead and submit your weirdest patent or strangest patent. And I'll go to that in a moment here. You can go and submit to your weirdest patent to the chat here. If you send us the patent number, also, if you send us the title and even an image, we can look that up though if you don't have all that information. But we can go ahead and get that added to our contest for later today. We've already had about 5 submissions. This is a submission that we have our team internally found. We have a couple dog lovers on the team, and they found an interesting one here where it protects animals' ears so that when they're eating food, they do not get wet or get all soiled. So these are kind of the kind of the theme or what we're trying to little fun and games for later. Hopefully have a couple chuckles is what we're hoping for there. So what we're going to be pivoting over to first, our first presenter, who is getting ready in our backstage, is Michael Sartori. And Michael is based in the DC metro area, and he is a partner from Baker Botts, which is a leading global firm and second oldest law firm west of the Mississippi, as a fun fact. He has an extensive background in patents with almost 30 years in patent law, ranging from starting out as an examiner actually, to a partner now at Baker Botts. And I know members of our team were actually just in a conference in Atlanta, or actually in DC with him last week, where we were joking about his examiner score in PatentAdvisor. Michael will be leveraging his expertise to dive into the development of high quality data-driven patent portfolios. And let me just make sure he is ready to go in a minute. He'll jump in and start sharing his screen. But again, just as a reminder, everybody, as Michael is about to come into the live webinar here, is as the presentation is going on, you'll see there is a Q&A button. Please feel free to ask questions at any time. and we will be able to look at those chat requests, those Q&A requests, either handle them from our CSM team that is here and ready to discuss, or to go ahead and actually have the panelists answer it if it's more directed to the subject matter that they are discussing. So please feel free to put those questions in. Also, you can in the Q&A, if you have your weirdest or strangest patent submission, you can put those in there as well too. And again, as a reminder, if you are not able to attend the entire day of sessions, we are going to have these recorded. They will be posted in the future once we go through and get the audio quality and the day produced from a video content perspective. We will have those posted, as well as Marco was mentioning, we have other user meetings that we've done amongst our different regional communities. Those will be posted in the future as well alongside this. So just more content that we will have that you can have available readily. So with that being said, looks like Michael is ready to go. So I will pass it over to him since we're already on the introduction. Michael, thank you very much for your time today. We're very gracious that you're able to putting the presentation together and to speak to our user community regarding your expertise in developing high quality data-driven patent portfolios. So thank you, Michael.
Sure. So let me go ahead and share my screen here. Okay, great. So can we see the screen? Anybody confirm that?
Yes, we can, Michael.
Okay, great. Thanks, all. Appreciate it. Okay, great. Okay, so hello. Good morning. I'm Dr. Michael Sartori. I'm speaking with you from BakerBots here in Washington, D.C. I'd like to thank LexisNexis IP Solutions for this opportunity to speak with you today on a subject that I really enjoy talking about. I particularly like to thank and give a shout out to Mary Nagel, Katie Brown, who is speaking a little bit after me today, Denise St. Ives, Shelley Sombrero, Carrie Forsyth, Maria Marino, Stacy Olkowski, who's also presenting later this afternoon, also Nick Valentino for putting this great event together. I'd also like to do a quick shout out to some of my friends that I know are tuning in today, Adan, Amir, Michelle, Kavita, Brock, Ryan, Steve, and Tanaka-san. Thank you so much, guys, for joining. I appreciate it. As a bit of background, I'm a patent attorney and a partner with the Washington, D.C. office of BakerBots. My practice focuses on patent preparation, prosecution, and counseling. I've been with BakerBots for nearly 4 years, and previously I served for over a decade as chair of the patent prosecution and counseling group at another AmLaw 100 firm. I'm also a former patent examiner with the U.S. Patent and Trademark Office, and prior to becoming an examiner, I earned my PhD in electrical engineering and received a number of patents for my own inventions. I work with companies in securing patents for their innovations in numerous areas, including high-tech software, consumer products, medical devices, manufacturing, chemical, material science spaces. To date, I have obtained well over 2,000 patents for my clients. But today, our topic is development of high-quality, data-driven patent portfolios. So we'll cover 2 topics today, examiner analytics, 3 topics, examiner analytics, but looking at the USP2 examiner type, doubling the effort, and examiner experience. We're going to explain some of the research we've conducted on different types of examiners at the USPTO and how these different examiner types can impact patent prosecution with vastly different results. We have found these results quite amazing and are very happy to be able to share these with you today. Okay, so we actually have a 4-part series of articles that were published in IP Law 360 in 2020. Summary article was published in IP Watchdog in 2021. Another one was published by Law 360 earlier this year. These articles received a lot of attention. In fact, the first part of the series was announced to be the 5th most read article by Law 360 in 2020. I'm really happy to discuss these results with you guys today. The topic explored the results of our research, which indicates the type of examiner examining your patent application can fundamentally impact the path your application takes at the USPTO, and also the experience you're going to have. First, we'll discuss the three different types of examiners. Then we'll look at what research indicates that the examiner, depends on the examiner types you get, your efforts in pursuit of a patent can be double or more. Third, our research indicates that the user experience of an examiner can greatly impact your prosecution experience at the USPTO. So first, let's look at the three different examiner types at the USPTO. Can you categorize examiners at the USPTO? Most definitely, yes. Moreover, patent procurement at the USPTO is affected by the type of examiner. The LexisNexis PatentAdvisor database provides a qualitative measurement for each examiner at the USPTO, known as the Examiner Time Allocation, or the ETA. And the ETA measurement is a proprietary calculation of LexisNexis. It's based on a number of factors for each examiner, including allowance rate, number of patents issued, number of abandonments, pending applications, and years of service. So the ETA measurement is a unitless, unbounded positive number with values starting at 0.1. Each examiner is placed into one of three categories based on the ETA measurement, and green with an ETA of 0.1 to 2.5. And green examiners tend to have a shorter prosecution length and grant more patents each year. Yellow examiners with an ETA of 2.6 to 5.9. Yellow examiners tend to have a longer prosecution length and grant less patents each year. And finally, red examiners with an ETA of 6.0 or more. The red examiners tend to have the longest prosecution length and grant the least number of patents each year. Patent procurement at the USPTO is affected by the type of examiner, and we have been using the PatentAdvisor database for some time, and we became curious as to whether the dynamics we were seeing in the database were the same all the time or changed over time. So we decided to undertake a study of the database by collecting and analyzing over a decade of data. With the help of several folks here, we gathered the decade plus of data. We decided to focus on the 8 non-design tech centers at the USPTO and disregard the design tech center due to its outlier statistics. So just utility applications, examiners that are examining those. With the collected data, we analyzed many metrics that span the life cycle of patent application. This was a very intensive effort. But based on our research and our experience with the data, we believe that understanding and being able to use examiner metrics can greatly enhance your ability to effectively manage a patent portfolio. So using the LexisNexis PatentAdvisor database, the number of green, yellow, and red examiners for each of these 8 non-design tech centers was gathered for the years 2009 to 2019. This figure illustrates the percentage of green, yellow, and red examiners for each of these 8 tech centers, where the total for each year vertically is 100%. So over the period, the percentage of green and yellow examiners has diverged from approximately 40% each year in 2009 to approximately 35% and 45% in 2019, with the averages of 37 and 44%. Oops, sorry. The percentage of red examiners was 20% in 2019 and has remained relatively constant with an average of 19%. But what I find fascinating about this data is the consistency in the percentage of each examiner type over the period. With the calculation of the ETA for each examiner type, they're actually fairly consistent. The red examiners are about the same at around 20%, and the percentages of green and yellow examiners are about the same also for the last 5 years or so, with a 45-35 split. What about the tech centers? So this figure illustrates the distributions of the examiners across these 8 tech centers that we reviewed for the decade plus of data. For each tech center, the blue bar indicates the percentage of examiners overall in the tech center. So all those blue bars together total 100%. And as you can see, Tech Center 2800, which examines semiconductors and circuits, has the most green examiners and also the highest percentage of all examiners. It has the largest blue bar. On the other hand, Tech Center 3600, which examines business methods, inventions, has the most red examiners. So what you should note here is the relative consistency in distribution of examiner types in 6 of the 8 tech centers, with the exceptions of 3600 and 2800. This figure illustrates the percentage of US patents that each type of examiner issued over the time period. As you can see, the percentage of all US patents that were issued by green examiners is over 50%, and is more than those issued by yellow and red examiners. And over the time period, although the difference in the percentages of US patents issued by green examiners and yellow examiners has narrowed, the average percentages are approximately 60% and 35%. In contrast, the percentage of US patents by red examiners has remained pretty consistent at 5%. This figure really shows the dominance by green examiners over the time period in issuing patents, and it's contrasted with the consistently low amount of patents issued by red examiners. With the data we collected, we can also look at the impact of the examiner type on the overall dispositions of patent applications. A disposition, combining the data of these prior figures, we see that 35% of the examiners, the green ones, allow 60% of the patents, and 20% of the examiners, the red ones, allow only 5% of the patents. So in other words, we have few examiners allowing many and many allowing few. So what are the key takeaways from this section of the presentation? So you should understand that examiners can be categorized into 3 categories with the PatentAdvisor database: green, yellow, and red. And across the 8 non-design tech centers at the USPTO, the distribution is approximately 45% for yellow, 35% for green, and 20% for red. Further, each of these tech centers has a significant amount of each examiner type, and the distribution is similar but not exactly the same, resulting in different and disproportionate contributions to the patent procurement process at the USPTO. From the study, you should also appreciate that patent procurement at the USPTO is affected by examiner type, where green examiners allow and examine disproportionately more applications than yellow and red examiners, which translates to few allowing many and many allowing few. Okay, so next, using these examiner types that we just discussed, we can see that a doubling of effort occurs between the examiner types. So our research indicates that the impact of the examiner type is not only evident in the number of patents issued and applications disposed, but also in every metric we examined in the life cycle of a patent application. Note that I said every metric. In fact, we saw that the examiner type between green examiners and red examiners can cause an applicant to double their efforts to obtain a patent. And due to this distortion, knowing the type of examiner can really help an applicant anticipate the likely costs to obtain a patent and the amount of effort needed to do so. So let's next look at the results of our research for these different metrics in life cycle of patent application. This figure illustrates the allowance rate for green, yellow, and red examiners, as well as all examiners combined, which is the blue line there in about the middle. As you can see, the allowance rate for the green examiners is higher than the average allowance rate, while the allowance rate for the yellow and red examiners is consistently lower. And based on this data, the examiner type impacts an applicant's chances of obtaining a patent. The average allowance rate for all examiners, which is the blue line, is 70% for this data set. For the green examiners, the chance of obtaining a patent has steadily increased with an average of 81%. For the yellow examiners, the percentage also increased with an average of 64%. And for the red examiners, the percentage has ranged from 25% to about 45% with an average of 38%. Comparing green examiners and red examiners over this time period, if an application is examined by a green examiner, the application is at least twice as likely as being allowed than if examined by a red examiner. Here is a first example of this doubling effect appearing between green examiners and red examiners that we saw in the data. Of note, the allowance rate for red examiners is much lower and had a 10% dip in 2014, which we believe can be attributed to the L.L.C decision from the Supreme Court and its impact on Section 101 rejections by the USPTO. In 2019, the red examiners had an uptick of about 10%, which we believe could be attributable to the 2019 Section 101 PEG guidelines for the USPTO. You will note similar inflections in the data that we analyzed. So office actions. So how many office actions are needed to obtain a disposed application from a particular examiner type? This next figure illustrates the average number of office actions required to dispose an application. Comparing green examiners and red examiners over this time period, if an application is examined by a green examiner, the application will require around half as many office actions than if examined by a red examiner. In other words, about twice as many office actions can be expected if a red examiner examines an application instead of a green examiner. Another doubling of effort. So how many years will it take to obtain a disposed application, for each examiner type? This figure illustrates the average time to disposal for an application for each examiner type. Comparing green examiners and red examiners, especially in recent years. If an application is examined by a green examiner, the application will take about half as long to reach a disposition than if examined by a red examiner. In other words, an application will be pending about twice as long if a red examiner examines the application instead of a green examiner. Another doubling effect. What about after final practice? One common strategy is to file an RCE. However, the USPTO does require significant fees for RCEs. So let's look at some statistics on RCEs. This figure shows the percentage of applications with at least one RCE. Comparing green examiners and red examiners, applications examined by red examiners have well over 2 times as many RCEs than green examiners, especially recently. This results in more expensive applications when examined by red examiners than compared to green examiners. If you believe the examiner cannot be persuaded to allow an application, an appeal to the PTAB is one of your options. This option has official fees, which includes an appeal fee when the notice of appeal is filed and an appeal forwarding fee to forward the application to the USPTO board. So this graph shows the percentages of applications with at least one appeal. Comparing green and red examiners, applications with red examiners are appealed more than 3 times as much as with green examiners. Recently, however, with this data, the percentages was even worse. Red examiners are being appealed 6 times more than green examiners. This graph shows the percentage of applicants winning on appeal. Even though more appeals are taken with red examiners, the success on appeal is opposite. The chances of an applicant winning an appeal are greater, 15% greater in the data here, for green examiners than red examiners. So the chances of winning an appeal for an applicant are less for a red examiner than a green examiner. We believe this difference may be due to the longer prosecution history with red examiners compared to green examiners. With a longer prosecution history, red examiners have more opportunity to find better prior art and or refine the rejections. As such, on appeal, a red examiner may tend to have a more well-reasoned and clearer position than a green examiner, which may explain why applicants have less success with red examiners than with green examiners on appeal. In summary, the data shows a great difference in the amount of effort that is required when an application is examined by a green examiner instead of a red examiner. This difference is at least a doubling effect. This table here I'm showing summarizes the comparisons we discussed in the last section here. This doubling effect manifests itself in a greater cost savings for applications examined by a green examiner compared to those examined by a red examiner. As such, in practice, knowing the type of examiner for a particular application can really help you predict the effort and the cost needed to obtain a patent, and also strategize on how to handle each application. Okay, so next we can apply what we just learned and look at the examiner experience as well. So let's consider the impact of examiner experience, yay, on the different prosecution types. As shown in this figure, the LexisNexis PatentAdvisor database not only identifies each examiner as a green, yellow, or red examiner, but also provides an estimate of the years of experience of each examiner. Using this database, data was gathered on January 3rd of this year, 2022, for all pending U.S. patent applications in those 8 technology centers at the USPTO we discussed before, the non-design tech centers. The examiner data was sorted based on the years of experience of each examiner, and the numbers of green, yellow, and red examiners for each experience year were tabulated. In this figure, the x-axis is the years of experience from 0 years to 35 years, and the y-axis is the tabulated number of examiners with that number of years of experience. The green, yellow, and red curves you can see are the numbers of green, yellow, and red examiners, respectively, for each year. As you can see, the distribution of green, yellow, and red examiners is disproportionate based on the examiner's years of experience. Red examiners dominate through the first 5 years of experience, and then yellow and green examiners dominate thereafter. For 20 or more years of experience, green examiners are the majority of examiners. Also, if you look at the data at the tech center level, just the next level down at the overall general data, the distribution has similar patterns. So this data, which in that data you can see in a recent article we published earlier this year if you want more details on those ones. So not only does the PatentAdvisor database provide years of experience, it also identifies whether an examiner is a primary examiner or not. A primary examiner is an examiner that has passed the signatory authority review program at the USPTO. As a primary examiner with signatory authority, the examiner is permitted to sign numerous types of actions. As such, if an examiner is not a primary examiner needs to sign the actions on behalf of the non-primary examiner. For the gathered data set, each examiner was further categorized as either a non-primary examiner or a primary examiner based on the indication in the PatentAdvisor database. As can be seen in this figure, the non-primary examiners tend to be yellow and red examiners. The numbers of red non-primary examiners are the most for the first 5 years of experience and are tied with yellow non-primary examiners at year 6. From the 7th year forward, yellow non-primary examiners have the most experience, and in comparison to red and yellow non-primary examiners, they're much less than green non-primary examiners. What about primary examiners? Okay, so this figure shows the data for the primary examiners. Primary examiners tend to be yellow and green examiners. The numbers of yellow primary examiners are the most through 20 years of experience, and then green examiners have the most experience from the 21st year and afterwards. In comparison to green and yellow primary examiners, there are much less red primary examiners. Further, there are very few primary examiners with less than 6 years of experience, and the numbers of primary examiners begins to steadily increase starting with 6 years of experience. Around 5 to 7 years experience is when an examiner can first become eligible as a primary examiner, which explains why there's so few primary examiners that have less than 6 years experience, because they're going through the signatory review program at that point. So in comparing the previous two figures, the less experienced non-primary examiners tend to be more difficult red examiners to the very experienced primary examiners, which tends to be the more favorable green examiners. So why the difference? Why the difference? So one theory that may explain the difference in examiner types between non-primary examiners and primary examiners may simply be that experience matters. Experience is important. For instance, new examiners may be extra meticulous examining applications, which may result in a large amount of red examiners with only a few years of experience. Further, a non-primary examiner with not many years of experience may still be trying to gain enough knowledge to understand the technology of the art unit, to identify, how to identify relevant prior art to apply in a rejection, how the patent rules and procedures should be applied, and maybe even when an application should be allowed. As such, an examiner, a red examiner, a junior examiner, may be hesitant to allow a patent application and may tend to issue more office actions, resulting in the red examiner type. On the other hand, a primary examiner with many years of experience may have acquired the knowledge and skill to understand the technology of the art unit, how the patent rules and procedures are applied, and maybe understand, and not really understand when an application is ready for allowance, where that line in the sand is. That's one theory, experience matters. Another theory that may explain the different distributions of examiner types between non-primary examiners and primary examiners may be based on the examiner quota system with the USPTO. So according to the quota system, each examiner needs to meet their quota, which is based on the examiner's GS level, which is a government schedule level. It's their level that they are hired at and are promoted to. The table here provides the so-called position factors and multipliers, which are calculated as the inverse of the position factors for the various GS levels. For primary examiners at GS 14 and above, the primary examiners are GS 14 and above, as the line indicates there. As such, a less experienced examiner at a GS 5 or a GS 7 has about twice as long to examine an application as an experienced primary examiner at a GS 14 or above. They indicated that multiplier being about 0.74 for the GS 14 and being 1.82, 1.43 for the GS 5 and GS 7. So as such, to meet their performance goals, according to the quota system, the primary examiners are required to have faster and more productive prior art searches and more efficient examinations than non-primary examiners. And these pressures may result in primary examiners tending to be more green and yellow types instead of red types. So finally, let's look at some of the conclusions of this presentation. So Dr. Sartori, what does all these graphs and all this data mean? Okay, well, this all shows that patent procurement at the USPTO is affected by the examiner type, green, yellow, and red. Further, the examiner type can predict prosecution experience across the metrics in the life cycle of a patent application, and even in patent litigation, as one of our articles showed as well. Comparing examiner types, at least a doubling of effort is needed when a patent is examined by a red examiner instead of a green examiner. So if you have a limited patent procurement budget, which many companies do, it's not infinite, you need to be as efficient and cost effective as possible. But you also need to develop a quality patent portfolio. Otherwise, it's all just a waste of time and money. So if you can be both cost effective and improve your portfolio, that's a win-win situation. So by knowing the examiner type, this can help you achieve such a win-win situation. In particular, knowing the examiner type can help you strategize on prosecution tactics, which path do we take next? Craft responses to office actions. How much do you need to amend the claims to obtain a patent? Anticipate the time needed to obtain a patent. Knowing the possible timing can be particularly helpful if the patent portfolio is closely tied to your product in the marketplace. Anticipate prosecution costs. How many office actions will you need? What are the chances of having a final office action? And will you likely need to appeal? So we regularly use examiner analytics to strategize with our clients and assist them in building their patent portfolios. We believe that determining the examiner type for your application can really, really help you make strategic prosecution decisions to save costs and to increase your quality. So for further reading, for further information on the information that we presented here, you can refer to our published articles on examiner analytics, which we have a number of them here shown. Happy to send any of you out there copies of these if you're unable to access them. And we also have another series on determining patent filing targets. This is also data driven as well. I didn't get a chance to talk about that today, but it's another technique that we use to develop high quality patent portfolios using another data driven technique, which ties the number of applications that you should be filing in your portfolio based on the amount of money spent on R&D. Happy to share with those of you as well, if you like as well. So thank you very much for your time today and your interest here. Nick or Al?
Yeah, thank you, Michael. I think we have actually a couple of questions from the audience that we can dive into.
Sure.
So the first one was put in through the that we have here in the chat was, and this is something maybe Michael we can tag team here. How much does the art unit and or supervisor impact examiner ratings through the examiner time allocation, the ETA algorithm, if at all?
Right, that's a good question. So some junior examiners do not have an ETA rating yet because they're so new. So in those situations, we like to use the statistics for the art unit, not necessarily the supervising patent attorney, but for the art unit, because you're not quite sure which primary examiner will be supervising the junior examiner. So you can kind of guesstimate a bit with the art unit. But sometimes if you do interview the examiner, you can find out which primary examiner will be accompanying them on the interview because they're too junior to interview by themselves. And so you can check out the statistics on the primary examiner, and that can help you also in terms of your strategies and how to proceed with the application.
And a little bit more information to add there regarding the art unit. So you can get insight into what the probability is of being assigned to one of the red, green, or yellow examiners within that art unit. So there's lottery maps that you can see based off of how quickly each examiner type is bringing their cases to disposition, how frequently they're going back into the assignment pool. So that's something that can give you a little bit of insight as well to see what is the distribution, not only the distribution of the examiners within that art unit, but what is the likelihood that you will actually encounter that examiner type as well too. So that's something else we can take into consideration.
That's actually a great tool. That's a great tool to use as well. Like I've used it several times, and it's quite interesting. So like it.
Yeah, perfect. Let's see. We have two more that actually came in as we were talking. If we are at final and the art cited doesn't make the claims obvious anticipated, how important is the difference between green, yellow, and red examiners to you in deciding whether to appeal?
It's very important. It's very, very important. At that point, the statistics we've shown today, these are general, very high level statistics, but when you drill down, you have to look at the examiner that you have as well and pull those stat sheets for the examiner. It's like doing baseball cards, flipping your baseball cards. If you find out what the batter is going to bat or the pitcher is going to pitch, you look at those ones, and you can actually look at the appeal processes. There's a number of things you can do: an AFCP 2.0, a request for pre-appeal brief. You can do a appeal brief with an amendment. There's a lot of ways to do. There's a lot of options you can have post-appeal, and the PatentAdvisor database has a lot of those. You can look at those post-final, after final options with your examiner, and you can help you make a decision. Sometimes it's very obvious what you should do. Sometimes not so obvious, and you can look at those and help illuminate your strategy.
There is actually a follow-up to that, Michael. Essentially the same criteria. So if you're at final, art cited doesn't make the claims obvious or anticipated, looking into account the importance of the difference between the green, yellow, and red examiners, now looking at it from a lens of interview and or RCE perspective.
Both those are great. Well, too. Both those are well. So you can look at the RCE numbers. You can see how many RCEs the examiner will have, and so you can kind of get a feel for how much time you have to grind away with the examiner. Sometimes it's 2 or more, 3. Sometimes it's even higher. It's really ridiculous. But you can see how much you have to grind away with them. You can also look at the number of office actions as well, too. How many you've only done 2? Maybe is it 2 office actions in your file, or do you have a couple extra non-files between those? You can look at those ones. Also, the interview statistics are very interesting as well, too. I didn't touch on those here today. I didn't present those statistics, but the red examiners are, more interviews with red examiners than the green examiners by a good 2x plus multiplier. So those ones, you can look at the individual examiner, and you can look at those, how well is the examiner interviewing. And so some clients don't want to pay for interviews a lot. Some do. It kind of varies a lot. But the interview statistics can be really, really telling. Have you interviewed with the examiner, or not? And from the interview statistics, you can tell does the success rate change with the examiner if you interview and without interview compared to the overall one. So sometimes you get examiners that you can see just love to interview, and there may be a 20 or 30 point difference between interviewing and not interviewing. And those ones you should recommend going in there, talking to the person they like to talk. Some ones are flat; it's the same one either way. So maybe why bother with the cost? And some ones are upside down, where the percentage of success with an interview is less if you interview than if you do not interview. And so those ones we should really think about should you going in there. Those when the examiners tend not to like to interview. I think you have to look at the sample set as well too to make sure it's a good enough sample size. But there are definitely examiners out there that do not like to interview. Good questions. These are awesome, Nick.
Yeah, we have one more, Michael.
Yeah.
And actually, this is a great question because it brings up the topic of litigation data, which
Yeah.
our product director, our senior director of product, Jonas, is going to bring up and discuss in his product showcase later.
Sure.
Has anyone co-related examiner types approvals with patent litigation data? For example, red examiners give more robust patents. Those from red examiners are not invalidated in litigation and vice versa.
Yes, we looked at this data a couple years when we put this data together. We had the fourth article in our 4-part series in 2020 looked at litigation data. It's actually quite interesting. I had a question on this at another webinar I did a couple weeks ago. So it turns out that if you look at the actually the data here from LexisNexis, you can look at the district court litigation and the PTAB IPR data. We have both those ones. So looked at those ones and filtered it through the red, yellow, green examiners. So it turns out there's a couple of black letter things you can look at. One is that most patents that are issued by green examiners are litigated. More patents issued by green examiners are litigated than by red examiners and yellow examiners, and so because there's more patents that are litigated by those. But percentage wise, there's a higher percentage of patents issued by red examiners that are litigated compared to yellow and green examiners, which is kind of interesting. For district court litigation, look at district court litigation of the data set we had. Patents that are examined by green examiners are 6%, 060, not 16, 0, just 6, 5 plus 1. 6% are more likely to have patent owner wins at U.S. district court litigations than those examined by red examiners. So green examiners have a little higher chance of winning at district court than those ones. So we think that in that sense, having a less prosecution history may result in a more favorable claim construction by a patent owner because you have a green examiner examining it, which could tend to result in the patent owner winning more often. You have less office actions, less final office actions, less interviews, less things in the prosecution history with the green examiners. You have red examiners, so there's less things to grind on for the claim construction. So green examiners are more likely to have a patent owner wins there. Now, it's IPR is the PTAB. It's a little different. Patents examined by red examiners are 33% more likely to have patent owner wins at the PTAB than those examined by green examiners. So patents examined by red examiners tend to have more prosecution history than patents examined by green examiners. So more prosecution history, lower allowance rate, more office actions, more final office actions, more interviews, more RCEs, more appeals, just grinding away on the prosecution for longer time disposition. So patents examined by red examiners would tend to have more, be more vetted by having more prior art and/or more narrowing claim amendments. So having a patent more vetted during the prosecution could tend to result in a patent less prone to invalidity challenge at the PTAB. And that's one theory on that one. Okay.
Perfect. Thank you, Michael. That's a very interesting analysis on that question. And I know something that we are going to be focusing on moving forward on how to integrate litigation data as a supplemental to a lot of the data we already have in our system. So appreciate the questions from the users. I think those are really great conversational pieces. Michael, thank you very much for your time today.
Sure.
I hope you were able to attend the rest of the session today. And thank you very much again. We really much appreciate the effort and the content that was put into this. So thank you very much.
Yep. Welcome. Thanks, Nick.
Thank you.
Next year. Okay.
All right. So next, I'm going to introduce our next presenter, Ted Wood. Ted is based in the DC metro area as well and is a managing partner at Wood IP LLC, which is a service-disabled veteran-owned minority business enterprise, boutique international intellectual property law firm. Ted is a retired Air Force Lieutenant Colonel with 40 years of high-tech legal and military experience. Ted will showcase how he leverages prosecution performance metrics within business development activities. So we're very excited to have Ted today to talk us through a use case that I know when we were coming up with topics for the sessions, I know this was very interesting and got me really captivated my attention. So I hope that does the same for everybody else. So Ted, pass it over to you.
All right, thanks, Nick. Can you see me and hear me okay?
I can hear you, Ted. We just need you to, we can see you now. Perfect.
Okay,
Yep. And we just need you just to share any content that you like.
okay,
Share
all
screen
right.
button. Perfect. Can see that.
Okay. So I appreciate the opportunity to speak with everyone. Again, I'm Ted Wood from Wood IP, and it's my honor and privilege to speak with you about showcasing the firm's performance over competitors using prosecution metrics. This presentation is going to be divided essentially into two parts. One, talking about the firm itself, and that is merely a precursor to jump into a discussion about prosecution metrics, and the pitch that will be a specific use case that sort of pulls together all of the different metrics and tools that we've used. And I'd like this to be informal. So if you have questions, just let me know. Now, they say a picture is worth 1,000 words. So these are our words. We are a diverse IP firm with an average of 15 years of experience in IP counseling, particularly in patent prosecution. This is our team here. There are 14 of us. And not only are we ethnically and racially diverse, we have different backgrounds and experiences. We include lawyers, patent agents, and one tech specialist. We are former examiners. 4 of our team members are former patent examiners. One was a supervisory patent examiner and a special laws expert out of the computer architecture art unit. Some of us were, the 3 of us were military members. We engineers, scientists, etc. And we have used patent analytics and examiner metrics for about 3, maybe 4 years, but a lot more in the last 6 months to a year. Here is a snapshot of our team. We include, let's see, so the 14 of us, 12 have advanced degrees. 9 of those are advanced science degrees, including electrical engineering, computer science, biotechnology, etc. Here are a few things that we sort of embrace. We typically, given our level of experience, we have an average of 15 years, but many of us have much more, myself included. And typically we will are given portfolios that tend to be a little bit more complex. We like to consider ourselves as persistent and relentless, and keep your focus on those 2 words because we'll come back to that. We particularly focus in the software area, and one of our team members now supports the Senate Judiciary Committee, the IP subcommittee that is rewriting 35 USC Section 101. He participates as a stakeholder, and one of our pursuits is increasing diversity and inclusion in the patent ecosystem. We've been doing this for a while. All of us have given presentations in the area of STEM, etc. Now, even if everything that I said before is true, and it was about our experience level, advanced degrees, etc., we are also a business, and that business depends on getting new clients. And for a small, relatively new IP firm, we've been around since 2016. Although that's between 6 and 7 years, not many people know about us. We're in an industry that is dominated by the more well-known marquee firms, the Finnegans and Menses, the firms that are listed here. And I'm not knocking these. All of us, and there are no exceptions to this, all of us grew up in these firms. For example, I started as an associate at Pillsbury Winthrop. And in those days, it was the Cushman, Darby and Cushman Intellectual Property Group of Pillsbury, Madison, and Sudcrow. I was a partner at Stern Kessler. All of our attorneys and practitioners spent time at Finnegan, Shagru, Baker, Foley, etc. But we have to compete against many of these same firms for business and for the same portfolios. They have a reputation, word of mouth. We talk about some of the things that we've done on our website, but that is not objective proof that we can do the work that we need to do to meet our clients' expectations. And so, one other thing we could do is spend a lot of money on marketing campaigns, very strategic, pinpoint focused. That costs a lot of money. Although we do some of that now, and we can increase our presence on social media. We do that as well, but that requires time. And time and money are two resources that are very limited to especially small business owners. But technology is changing the equation here. And I'm going to try and talk to you about a few of the ways that's happening. And I thought about the best way to do this, and what I came up with was using an example pitch that we did. And this is not really one pitch. Every time we do a pitch for a client, we learn how to use the tool a little bit better. And so when I say the pitch, this is actually a pitch to a number of different potential new clients over the last year or so, and each one uses elements that I will talk about. So I'm trying to let me back up a little bit here. I want to protect the names, so I'm using for the potential new client Acme Technologies. You'd have to be over a certain age to appreciate the name Acme. But it is an alias for an actual client that we were able to bring on board that significantly changed the position of our firm internally. And we use a number of LexisNexis tools to help form the strategy and messaging for that particular client. Here are some of the tools that we used in particular. And I know Michael, who preceded me, and others have talked about these specific tools, so I won't talk about exactly how to operate them, but these are things that we use to put our pitch together. Now, when we first started using PatentAdvisor 3 or 4 years ago, I had no idea what our internal allowance rate was, and to be frank, was a little bit fearful of knowing that. And we had been in conversations with LexisNexis for about a year, maybe 2 years prior to that, because they wanted to introduce us to these tools. I didn't have the time, didn't think we had the money, didn't have the interest. So someone said, "Hey, we did an analysis on your firm. Would you like to see it?" And with my knees shaking, it's kind of, how can I turn that down? And it turns out there was a lot of favorable information. Mostly favorable information there about our firm. And for a long time, we used simply our allowance rate in comparison to the USPTO overall average as part of our pitches to potential new clients. But the way we would do that would be, for example, if you're familiar with PatentAdvisor, we'd simply do a search for an assignee. We'd look at the dashboard, and basically with an 86.6% allowance rate, a lot of the clients that we looked at for whatever reason, and I'll back up a little bit, we all know that a lot goes into the allowance rate. So I'm not patting myself on the back, or certainly not breaking my arm over our allowance rate, because a lot of stuff can influence that. But when we use these tools to help us prepare for a pitch, and the potential new client's allowance rate is lower than ours, then it becomes, we're somewhat better positioned to go to the next screen in PatentAdvisor and pick any of these different areas: rejection, specific statistics, office action, average times, look at particular examiner statistics, appeal statistics, and offer, as part of our pitch, some advice on how to help that potential new client in terms of value we can add, have more successful patent prosecution strategies. Now, one client, however, that we wanted to do a pitch to, when we looked at their dashboard, turns out they have a 91.7% allowance rate. And I was like, holy crap, what can, and as a firm, all of our senior leadership got together, and we looked at every category. I mean, specifically for this client, we looked at all of these statistics and couldn't come up with anything. I mean, it's how can someone with a lower allowance rate offer advice to someone with a slightly higher rate? Now, as we came down, we started to, somebody suggested that we pool their applications, which we did. And we looked at random at maybe 8 to 10 applications, looking at sample claims. And we actually pulled one of their applications and went through the claim pretty carefully. And one common denominator, so this is the first page of this claim. This was one of their allowed claims, page 2, and this is page 3. And as we looked at that claim, we had a eureka moment, because most of the claims that they were getting allowed were relatively long and narrow. But the question is, why? So in preparing the pitch, we didn't want to talk about this in a way that was critical of this company or of any attorney inside, but we did want to know why their claims seemed to be longer and more narrow. Was it part of their patent strategy? And as it turns out, what we offered was our ability to help obtain broader claim protection. And the reason why their claims were narrow was a combination of things. Now, they did want to, some of that was intentional, where they only worked, or bet the farm on those key technologies. But some of it was because of their particular prosecution style. And so that observation led to an impromptu discussion during the pitch, which we reformed later pitches to accommodate. But during that pitch, the chief IP counsel wanted to know, what would we do? What specific things could we do to help provide broader claims, right? What can you guys do that we aren't doing already, especially being a newer, smaller firm? And so here are some of the things that we talked through, impromptu. I mean, I had not prepared for this at the time to go into this. And these are some of the things that we did. One thing is the de novo case review. So when we get an office action for a case, even if it's a case that we wrote, we give very little credence to the pending claims. And so the goal is to ensure that all of the claims focus on the invention as described in the application. The claim has to be technically accurate. So when I review cases inside the firm, we want to make sure the attorneys understand what the invention is and make sure that that is captured in the most efficient way possible. In terms of interview strategies for the examiner, we want to make the examiner part of the applicant's team. And, invariably we'll call an examiner if he knows the case very well. In some cases, they want to get right into the case during the phone call to set up the interview. So we have a policy where before you contact the examiner, you want to have plan A, plan B, plan C, everything in your hip pocket, and be ready to talk at that moment. Now, one other tool that we use is, so in cases where we believe the examiner is being uncooperative or obstinate, or a case where the examiner is simply wrong, the art does not read on the claims. We've started using the USPTO Ombudsman program and have had success in a number of cases where the ombudsman, and it is a formal program at the USPTO, that office will assign I think, as I recall, each technical center has their own technical director, a person who is a supervisory patent examiner, is familiar with all the technology, and is in a leadership role, typically a GS-15. And we've used the ombudsman in many cases and had the ombudsman to overrule the examiner and to agree with us that the claims are patentable over the art, and had the ombudsman to allow those cases or force the examiner or entice the examiner to allow the case outside of an appeal. And we've done that on a number of cases. So we pull out all stops in getting cases allowed, and we take this process personally. But is there any objective evidence that we know what we're doing? And in fact, in this case, when we looked at the long claim, excuse me, we were prepared to look at an example that we did in cases that we pick up that others have prosecuted. We'll look at the claim, apply our de novo approach. Here's a before example, and this is an actual claim that we were able to get allowed. We looked at the claim as it was filed, read, discussed the drawings, the specification. As it turns out, the claim was not focused on the invention. Once we did that alignment, added a new set of claims, we were able to get that case allowed. That was one example that we were able to offer in that particular session about what we might do to help improve that client's performance and help them get broader claims. But here are some of the other tools that we use and have been using lately to showcase our performance, to help show that we, in some objective way, that we know what we're doing, besides relying on our certifications or degrees or experience, that kind of stuff, because that's what's going to move a potential new client, that you can do the work. And so as we looked a little bit more deeply into PatentAdvisor and working with LexisNexis and their team, as it turns out, there were metrics that could support the contentions that we were making, that typically we worked harder, especially with tough cases. So for example, this statistic that is based on the application complexity shows that for a given examiner, again, the lighter color is the examiner, the lighter color is wood IP, the darker color is the examiner, that the average words per independent claim for us are less than that typical examiner would allow. And that's one of the things that we fight for pretty strongly. And when we looked at the data even a little bit more deeply, we were able to find other metrics that supported exactly where we were and some of the successes that we had in patent prosecution. This is a graph that shows US PTO allowance rate versus PatentAdvisor's efficiency score. So it's a measure of how well or successful are we in getting cases allowed, juxtaposed with the speed and efficiency upon which we do that. And it also breaks the data down in terms of the color of the examiner, as Michael was saying in his presentation a few moments ago. Now, again, I'm protecting the names of the innocent. I would not want anybody sort of casting, what could be perceived as making disparaging remarks about wood IP. So I'll say this much, that each of these marquee firm names, marquee firm 1, 2, etc., and all of these other IP firms are places that each one of us, each one of you would know. And these are the top tier firms that if you Google top 10 or top 20 patent firms in the US, these are those names. And so wood IP is looking pretty good in comparison to marquee firms in terms of our allowance rate, in terms of our efficiency. When we looked at the data a little bit more deeply, here is the success score for red examiners. As Michael and others have indicated, dealing with the more difficult examiners is something that we use all of the available tools procedurally to push cases through. And there is this objective proof here with with an efficiency score of 75 in comparison to marquee firm 2, the potential new client themselves, who had the lowest rating, and another marquee firm. We came out pretty well with red examiners, which again supports our contention that we sort of pull out all the stops when it comes to getting cases allowed. Now, this is the USPTO average allowance rate. But what's helpful for us is if we can look at the technology centers where our clients tend to file most of their patent applications. So here is a look at the same sort of analysis at Technology Center 2600. And as I showed in one of the earlier slides, Technology Center 2600 deals primarily with communications. And so when we looked at that, let me go back. So when we looked at that, we're looking even better. Now, our sample size is smaller, but when we look at, in this case, we didn't have enough cases to provide any sort of measurable performance for red examiners. But for yellow examiners, looking at our allowance rate and our efficiency, especially in comparison to these larger marquee firms, I have to admit, I was surprised and even more impressed, with our firm. And again, these are using the tools. This specific tool is the PatentAdvisor law firm report card. And none of us wants to get a report card. I don't think, at least I didn't when I was in school, unless we absolutely have to. So I was a little bit hesitant to even look at the law firm report card. But when I start digging into the data, there was a lot of good data there to help us provide some objective measure that we know what we're doing, with respect to patent prosecution. So again, this is Technology Center 2600, Technology Center 1600 for biotechnology, shows the same thing. We're in a pretty good spot in comparison to the other firms that support a particular client. And now there's a lot of data there, and it took us a while to be able to find the data that kind of supported our message. But without these tools, it would have been impossible. And without this kind of technology, we're left to simply using words to try and persuade clients to give us new work. But these tools provide another component that makes that process a little bit easier. So these are the key takeaways here. I talked a little bit about our profile and some of the business development challenges for new firms in particular, new firms generally, and IP firms in particular. But technology is changing the game. There is so much data that is available now that pretty much you can fashion your messaging and your strategy based on data that casts your firm in a pretty favorable light. So that's all I had. I open it up for questions.
Thank you, Ted. Let me look at the question. We have a couple questions in the chat. Again, we have a question here about, we're looking at the red examiners and your firm's performance compared to the other kind of firms you highlighted, or just firms in general. And I know we've talked, as we're prepping for this, the red examiners are kind of like the sweet spot area for your firm.
Yeah.
Again, without giving out too much of the secrets, there was a question about what type of processes do you have in place to handle those cases more efficiently, to have that much higher of an efficiency rate?
And these are things that have sort of developed organically as we've gone along. because we're a small firm, I'm able to review personally most of the work, actually all of the work that goes out of the firm. But for those cases with red examiners, we even look at those beforehand and determine, is there something that we can do? Because we've had red examiners with the 0% allowance rate, and not new examiners. These are examiners who've been at the PTO for 7 or 8 years and have a fairly significant caseload. But our de novo review, so when we get a case, especially for a red examiner, we want to tear the specification apart, and we're reading it word for word. We're looking at every figure and trying to understand, trying to get in the mind of the inventor when that application was filed. So what is the invention? What is it? And does this claim read on that? And so, we discuss this internally. Typically for cases like this, we'll have another attorney, we'll assign another attorney, not the same one that prosecuted it earlier, but another attorney who can put a set of fresh eyes on it, typically a more senior attorney. And we look and discuss what the invention is before we even look at the claims. And during that prosecution, basically, we don't print out the claims that are pending. We go through, review the specification, and kind of do a draft claim like we're writing it from scratch and compare that with the pending claims. And in about half those cases, there is some essential feature of the invention, of the novelty of the invention, that's missing. And so that sort of adds a new feature to that prosecution. And again, if the red examiner is dead wrong, and in a lot of cases, these are more senior examiners, we call up the ombudsman, and in a couple of cases have actually called the examiner supervisor, because we don't want to spend clients' money to do an expensive appeal if there are other ways around it. And we've had supervisors to intervene, enabling us to avoid having to appeal, and we've had the ombudsman also to intervene. And those are just a handful of the processes that we use for red examiners.
And it's a bit of a follow-up question to that came through. Does that strategy, you'd shown a few different technology centers, does that strategy vary or differ based off of the technology area that you're focusing on for that case?
So not really, because the de novo review that we do is the same for every technology area, reaching out to the ombudsman. And again, we can only reach out to the ombudsman in very limited cases, but those cases reveal themselves. And I'm sure you each have had a case where the examiner is just wrong. Either he or she is misreading some feature in the application, or misinterpreting some figure, and so in that case, when the examiner is dead wrong, we'll reach out to the ombudsman. If it's a close case, we'll consider whether we want to do a pre-appeal brief or a full appeal, because again, we can take it out of the hands of the examiner and put it before his peers in a pre-appeal brief conference request. And so with the examiner, would he succumb to peer pressure, or is this something we need to elevate up to the PTAB? And so these are considerations that we make, and again, we go back and look at the specific examiner and his appeal statistics. Are we likely to win? Has he, in some cases, these examiners rely on RCEs because their appeal statistics are very low, and so the applicant is better appealing than filing an RCE. So, but we use all of these tools sort of in the same way, regardless of the technology center.
All right. That looks like that's it for the chat. So with the questions that came through, Ted, thank you very much for the presentation and for answering those follow-up questions. Very valuable.
Thanks, Nick.
And if anybody, again, has any further questions for any of our panelists or for our team, even after the sessions, if something comes to mind, please feel free to send those through, and we can always follow up with you and the panelists individually on those questions. So Ted, appreciate, again, very gracious for you to spend the time to talk with us this morning and to talk with the community. And yeah, thank you very much.
All right, thank you for the invitation. Much
Yeah.
appreciated.
All right, so at this time, we are going to take a 15-minute break, and we are going to resume the meeting at 11:45 Eastern time with our next set of sessions. In 15 minutes, we'll have a tips and tricks. And then in 30 minutes, we'll actually have our next speaker. We'll have our first product showcase. So the webinar will be down for the next, well, you can hang in the webinar, but we'll come back in 15 minutes with our next quick tutorial session on TotalPatent 1, integrating with PatentSight, and then we'll have our first product showcase in 30 minutes at the top of the hour with our PatentSight product. So thank you, everyone, and we'll be back in a few.
I'm joining the webinar.
Yourself.
Okay. I think everyone can hear me now. Should be unmuted. Okay. I'm going to go ahead and get started. So hi, everyone. My name is Katie Brown. I'm a customer success manager here at LexisNexis. And I'm going to be today showing you how you can quickly and easily import your patent search results from TotalPatent 1, our patent searching tool, to PatentSight, our patent analytics and business intelligence platform. So this is a really wonderful feature for our customers who subscribe to both solutions and who may prefer to begin conducting their patent searching in TotalPatent 1. So first, we're going to begin by creating a search in TotalPatent 1. So today I'm going to do a pretty simple search to identify patents for blockchain technologies that are published in the US. We will then be sending these results to PatentSight for a landscape analysis of the blockchain technology space. So right now, we are seeing the homepage of TotalPatent 1, and it will allow you to search by building a query in this text box at the top. You can even click Edit in Full Page to expand your view. And you can also use our search fields that will help you build your search as well. If you scroll down this page and you click Add New Field, you can see all of the search fields that we have available. As you can see, we have quite a few: text search, name options, authority, date ranges, as well as pharmaceutical data, which is a newer feature in TotalPatent 1 if that is of interest. I'm going to go ahead and close out of the options and start to build my search. So the first search criteria I'm going to put in, I'm going to be searching the title, abstract, and claims for blockchain as my keyword. As you can see, when I type in my search criteria in the search field, it begins to populate in the text box. These two work in tandem. Next, I'm going to include some CPC codes that I know are the most common CPC codes for blockchain technology. In TotalPatent 1, we have this lookup tool that can actually help you identify relevant IPC and CPC codes to help you build your search. So this is valuable for anyone who may not know every single IPC code or CPC code that they're looking for, but they can input keywords to find relevant technologies, relevant classifications. So for me today, I know what the relevant CPC codes that I would like to search for, so I'm going to go ahead and input those. So I'm going to begin with H04L. Next, I'm going to search for G06F. And then finally, I'm going to include in my search G06Q. So I've got my relevant CPC codes I'd like to include. And then finally, I want to only look at published both applications and granted patents in the US. So in the publication authority search field, I'm going to input US. Okay. So now my search is ready, and I'm going to go ahead and complete my search. So I'm going to click search here. So now my results have come up, and I have over 14,000 records found. I am in the publication view of TotalPatent 1, so I'm seeing all published applications and granted patents that fit my search criteria for blockchain. If I did toggle over to family mode, I would be able to see a deduping of these results and see just one representative member per family. So now that I have my results, I am ready to import my results to PatentSight for an analysis on these patents. So the first thing that I'll need to do in order to enable this functionality, I'll need to select at least one of these results. I'm actually going to go ahead and click this checkbox at the top to select my entire list of results. And then I can click on this graph icon that's shown here above the results to send my selection to PatentSight. So I'm going to go ahead and click this. I'll receive notification that it's been successfully done. And then it's going to automatically redirect me to PatentSight in a new tab. When you do this, you may be prompted to log in to PatentSight as well. So now I'm in PatentSight and I have my search results, which are automatically imported right here into the search panel. They are actually saved as a tag here. Right now, they're named TotalPatent 1 Auto Import with today's date. You can see that when they've been sent over to PatentSight, PatentSight does all analyses at the patent family level. So we actually have over 7,900 patent families that are populated in our search results. So there are a few things that I can do with this tag of patents. So in PatentSight, a tag is a saved group of patents. I can click on this tag and I can edit the name if I would like. So I'm going to go ahead and rename this with today's date. And click save. And confirm this. And now this way I have a saved tag. So I have this saved group of patents that I can use additionally in a later analysis. So if I were to want to use it again in a search, I could just click on tag and then go under my username and then locate that tag when I want to do a future search for the same group of patents. So now going back to my analysis. So these patents have been loaded here, and now we actually have as a default 3 analyses that can give you some instant insight into this group of patents. So the first thing that we have done is we can see for this group of blockchain patents, the ultimate owner's portfolio position graph. What this is showing us, it's comparing the top owners in this field from both a quantity and a quality perspective. So we can see a comparison of the portfolio size as well as the average number of subsequent art citations for each of these owners to see how they compare. Additionally, we're seeing the top 10 IPC groups that are in our search results. So the most frequent IPC codes that come up for blockchain. And then finally, we're seeing the filing statistics with legal status. So this is actually the number of patents filed per year with the breakdown of their legal status of in force, pending, or inactive. One interesting insight you can see with this is that there really wasn't any significant uptick in this blockchain technology until about 2016, because of course it's a bit of a newer technology. So these are the default analyses that come up when you send your results over. But of course, you can do any sort of analysis that you would like to do. So if you open up the analysis templates panel, you can actually create a new analysis based on this search as well. So I had mentioned at the beginning that we did a search for all blockchain technologies, specifically published in the US. So we can then do a benchmarking or a landscape analysis on those patents. If we click into use cases, you'll be able to open up graphs that fit any of these use cases shown in this list. And since I had mentioned that we want to do benchmarking, we can click on benchmarking and do a benchmarking analysis for these patents. So for example, we could open patent asset index trend. Oh, I actually do need to deactivate the inactive families here because this chart will only do an analysis on the active patents in this group. That may take just a moment to load. Here it is. So you can see here again, these are the top 10 owners in blockchain, and their portfolios progress over time. So you can see by reporting date and then their patent asset index. So what the patent asset index is showing, that is PatentSight's metric for assessing the innovative strength and quality of patent portfolios. So that's our exclusive metric that we use in PatentSight to assess this. As you can see in this example, Ant Group has the strongest and perhaps the most quickly and significantly rising in strength patent portfolio in this blockchain group. Additionally, we can open up a new analysis. You can always click this plus sign to open up a new sheet. Your same search will carry over for your convenience, and then you can open up a new chart. So maybe, for example, we would like to take a look at international protection strategies. And this chart is a matrix chart that compares, again, these top owners in blockchain and the authorities that they're active in order to see the geographic regions where they have their portfolios are strong, as well as potentially any white spaces. So for example, Intel actually has strong coverage in the US and China in this blockchain field. But unlike many of these other top owners, they have no coverage in Singapore or Canada. So it can just give you some insight into the internationalization strategies of these top owners in this field. All right. So I believe so okay. All right. So I have shown how we can quickly pivot with our search results from TotalPatent 1 over to PatentSight. I'll pause at this moment. Are there any questions about this this functionality or these tools? Okay. Well, I don't think there are any questions at this time, but if there are ever any questions, please do feel free to reach out to our customer success team. We're always happy to work with you as you are working with these tools and looking for best practices. Okay, so I believe at this time we are going to take a brief break, and we'll be back in just a couple of minutes. Thank you very much.
as well.
Well, thank you, everybody, for your patience. We're at the end of our break right now, and it's my pleasure to introduce Jonas, who is our Senior Director of Product. He's going to show us what's new and exciting coming in the future for our search and analytics tool, specifically PatentSight. So Jonas is joining us from Germany. So Jonas, thank you very much for joining us at the end of the day to speak to our North America user community here. And I will go ahead and give you the floor. So thank you.
Thank you so much for the nice introduction. It is always great to talk to customers and to listen and learn. That's mostly what I love to do, but today I also get to present. So if there is an opportunity or there is definitely an opportunity for questions. So happy to listen as well, learn feedback, and then ultimately share with you a little bit how we're thinking about our overall products. So I'll walk through kind of some of the investments that we're making right now in the applications and a little bit with our plan for next year. If there are any specific questions that you have on any of the topics, please always feel free to reach out to us. We're more than happy to answer any specific questions that you may have, or even share a little bit more on where we are. And taking it even one step further, let me make one other general statement. Everything that we're working on, we're always happy to show early to customers and get feedback on. So the way that we think about product development, this is not necessarily something that happens in secret. This should ultimately be something that we're working with you on, because our ultimate goal is we want to solve actual problems that you have, and that means ultimately also talking to you to ensure that the things that we're doing actually solve your problems. So having said that, I hope you can see my screen, and I will just jump right into the slides and take you through some of the stuff that we're working on. So at a very high level, we have 3 goals. We want to provide at the core best-in-class content, then on top of that, a best-in-class search experience, and then on top of that, best-in-class analytics experience. We can debate for a very long time, what does best-in-class mean and what is an experience and all of those things. But the reason why I wanted to share this with you is because for us, it all starts with the content that we have. No feature functionality that we build on top can make up for the lack of data and content, especially in the patent world, whether it's legal status calculation that is important, whether it's any metrics that we build on top, whether it's family definitions that we do. It all depends on having the best-in-class content. I'll get to that in a little bit, what that means for us and the investments that we're also making in that area. Then we get to search. So there are specific investments that we make on the search area itself and investments on the analytics experience to make sure that we continue to advance on those levels as well. But again, it all starts with content. On the content side, I want to make sure that you all have context to this. We have significant investments to, one, ensure that we have the best-in-class content. Our PatentSight application today has a different content scope as our TP1 application. So depending on which products you use, you actually have different legal statuses or can even find different patents. And that is because TotalPatent 1 and IPDD, those 2 products currently leverage the content from L.L.P, where we go out and work with the patent offices around the world directly to get content from them. Whereas PatentSight gets the data from the European Patent Office through a data feed called IMPADOC. And this is a little bit limiting because it turns out that the EPO doesn't have all of the patent content that we want to have, which is why in TP1 and IPDD already we have a more expensive set of content. This is something that we're bringing to PatentSight. Our absolute high-level goal is all the best-in-class content that we already have will go to all of our products. We're not going to discriminate products based on kind of what content is available. So that's really step one, and that's a massive investment for us that I'll share a little bit more on down the line. But ultimately, one of the big things that you can look forward to for PatentSight in the next year is we're going to significantly increase the amount of content. It's almost 20 million patent documents to increase coverage in markets, for instance, like India and others, to really make sure that we have comprehensive overviews for you across the globe. When it comes to search experience, I want to share a little bit what we're doing there on TP1 today already, and this is something that we will bring to other products down the line, including PatentSight. This is a feature called Guided Simple Search. Guided Simple Search ultimately is a feature that turns natural language input into syntax. There's multiple different features out there with our competition as well, where they do a semantic search and other AI tools, and there are many startups that try to solve this problem in a way. But where we want to start before we go out and do all kinds of similarity search and semantic search and all of those things, which we have in the roadmaps to do, the first thing for us to do is really like lowering the entry barrier to syntax searching. And we don't want to abstract away what happens when you actually type a syntax query. Because the problem with most AI features is that it is not apparent to the end user what actually happens and what has been searched for and what the underlying logic is and why the decision was made by the system to then show you the results that you see. So in order to tackle that, ultimately what we're doing here is we are translating natural input into syntax for you, and you can still edit that syntax. If you don't agree with our suggestion that we made, you can change it, you don't have to use it, but it's very clear on what the actual search does because the search itself continues to be a syntax search. And you could see our little demo here on the left. This is something that we have in TP1 today already. You can see the natural language input. It then kind of suggests a syntax. And if you then click on, yep, that seems like a good translation for my actual problem, you can just click one button, then run the search that way. And this is something that we're rolling out in the TotalPatent 1 product right now. The first 60 customers already have access to this. And we're rolling it out to another 200 to 300 customers this year. And if this is something that you're interested in on the TP1 side, please let us know. We're happy to prioritize you so that you get access to it. And this ultimate feature is something that we're thinking about bringing to PatentSight next year as well. So ultimately, it's about kind of lowering the entrance barrier, making it easier for you to even write queries in the first place. One more thing that I wanted to share then on the content side, which is really about bringing completely different types of content into our applications. And this is about litigation content. Here again, as an example from our TP1 product, really quick mock-up and very early days of design, what we're doing here. But you can already see that what we offer here in the result list is a litigation status. So it tells you if there was a case associated to it, is it pending, was it closed, who are the parties that fought. This is content that we're very happy about that that we're adding to our entire product portfolio. So the same thing is going to be true in PatentSight. There you will have next in the family viewer, next to the document view, you'll have information about was there a case, which means you can search for it. You can search by patents that ultimately had litigation associated to it, and then we will be able to help you and show you what the status of that litigation is. And further down the line, we also want to introduce kind of litigation metrics so that you can actually see things at scale, right? So it would be really great if I could be in PatentSight and understand for specific companies that I'm interested in, did they have litigation in the past? How often do they have litigation over time? Are there specific years where they have a lot? Do they win? Do they lose? What's their ratio? These kind of things, we're starting to look into how we can bring them into PatentSight, whereas in TP1, they're going to be a little bit more on the search side, where the use cases are more on kind of retrieval of the pure information of the actual document and then the associated case. So this is really a big investment for us because it's completely new content that is very much associated to patents, but I think very, very interesting, especially in strategic decision making around M&A decisions, or even just competitor monitoring or understanding how aggressive is a player in the market, right? So these are ultimately things that we're going to try to help you to understand and decipher by bringing this litigation content in. Let me say that this is content that is, again, as it says here, global patent litigation data. So I think this is very, very important for us. Our products today are all targeted at a global audience. And this means our content coverage needs to be global from the get-go. So we're not going to focus just on US cases or just on German cases. Our ambition is, and that's what we're currently doing, collecting litigation cases across the entire world and then bringing that into the application. This is something that we're actively doing already. And now the next steps are just bringing it into our products. talking about the global nature of our applications, there is something that we're going to release in PatentSight very, very soon. And by very, very soon, I mean on the 15th of November. And this is, we're going to release the PatentSight application in Japanese. So this might not be super critical for a US audience, but it's very important for us. It's a big change. You have seen in the past that we've changed the look and feel of the application. We completely modernized it and we rewrote all the text. So you've seen that most of the English text in the application is now much more precise, a little bit more accurate. So all of those things we cleaned up. And now we're doing this for other languages as well, where we're bringing Japanese to PatentSight on the November 15th. So in the top right corner, there's going to be a language switcher. If you have any colleagues that speak Japanese, they will be able to use the application Japanese going forward. And then we're going to add Korean and Chinese in Q1 2023 as well. So those are going to be the 3 languages that are going to have native support in PatentSight. And this obviously brings us to what does this mean for the actual content in the application itself? So today in PatentSight particularly, we do not support multi-language search, where you specifically only want to search in one of those languages. And that brings me to what are we doing with searching in PatentSight? Because I said best-in-class search, so that means we must be doing quite a bit going forward when it comes to PatentSight and searching. And yes, you're absolutely right. What I'm going to show you now are mock-ups, so very early days on kind of improvements to the search experience that we're having in PatentSight. We are working on bringing document-level search to PatentSight. What does this mean? Today, in PatentSight, if you make a search and you look at a result list, the result list will only give you the family member, so the family representative, and then the search hit in the actual document. You cannot get to the document hit directly. So in the result list, it's always families first. We are aiming to launch in H2 next year, document level search in PatentSight, which means we will have native support for family level searching as we have today, plus directly to the document. So that means we will only look for hits in specific documents. And with that, we're also bringing a ton more content that is associated to those documents, which from an experience perspective for us means we're looking at the document view and adding a lot more fields that you can search for. So we ultimately want to help you that you can even do FDO use cases and all of those use cases in PatentSight. And this for us means, one, is very much bringing all of the 20 million documents that we already have in our other products into PatentSight. And it also means bringing more search functionality and more search fields into PatentSight. With all of that, we then need to worry about, okay, what does that search experience even look like? And what you can see here on the left, again, very early mock-ups for how we're thinking about improving the fielded search to make it easier that you can nest and really see how is my query built up. And maybe even see some preliminary results. So if I have big brackets and end and ors in between, so that I can see kind of my sub results of building up a query. And these are all things we're working on right now. And we're also, and this is something I'm not going to show you today, but something that will come next year, significant improvement to syntax mode in PatentSight. So we will invest quite a bit to make it easier for you to build queries in PatentSight, bring then additional search field to PatentSight, and again, support document level search and alerting in PatentSight. The important notion for now is all of our metrics continue to be at family level, and that is something that will definitely be true. Further down the line, there's thoughts about how we can do kind of document level analytics, but this is nothing that I have any dates or anything like that on, but these are certainly things that are on top of our mind, and we're starting to think about how we could tackle these. At the very bottom here, last but not least, you can see kind of our little family switcher. So this is something that going forward going to allow you to pick between, do I want to search in families or do I want to search in publications directly so that I get to the documents. On that notion, let me switch slightly to what's coming very, very soon again in PatentSight, and this is an update to the UN SDGs. The UN SDGs are one of the most used features in PatentSight today, actually. Sustainability is one of the key topics that we hear from many customers. Ultimately, what we're doing is the underlying queries, we're going to improve them, and the underlying classification, we're going to improve that in early Q1. And with that, we will share a lot more material on how the classification works, what we're updating, what the differences are, and we will provide also rankings in the future on UN SDG updates. So this is something that we're quite invested in, as we hear more and more, especially from large industry players, that this is one of the key data points that they need in order to really break through with their internal stakeholders. Sustainability is not necessarily a typical IP topic, but maybe that is one of the key reasons why many of the IP leaders that we talk to find it as a wonderful opportunity to leverage this content, particularly to then drive discussions internally with other stakeholders on the importance of IP all up, to really show kind of the breadth of the information that IP data ultimately allows you to derive and ultimately leads to better decision making than in customers' decision-making processes across strategic and operational decisions, whether it's M&A activities or even just FTO searches. One more topic that I do want to bring up today is overall infrastructure investments that we're making. This is a very important topic for us. We have a clear priority on stability and performance. This continues to be a topic that we have a lot of resources invested in, and where we're confident that you will continue to see improvements throughout the next couple of months and certainly next year. This has multiple elements, kind of the infrastructure things that do not really bring a ton of features to you. One is sign up and sign in capabilities. As part of LexisNexis, PatentSight and all of our patent portfolio products, that includes PatentAdvisor, TP1 already has it, and PatentOptimizer, all of the products going forward are going to leverage the same SSO, so single sign-on technology, which means that you will be able to switch between our applications with just one login. So single login for all of our products, not multiple passwords and all of these things. If you have any other Lexis products, we will be able to use the same login capability that you already use for other Lexis products. So we're going to use the same SSO as Lexis does, as you can see here, fully branded. And this is something that we work very closely with the Lexis security teams on the login capabilities. So this is absolutely something that's going to come in 2023. We're already starting to work on it right now, but I don't have a final date of when it will be in PatentSight, but certainly something that should make your life a little bit easier. On the investment side, regarding other infrastructure items, search infrastructure is absolutely critical to us. We know that sometimes waiting on a query can be very annoying. So we're investing quite a bit to make our overall search infrastructure just a lot more resilient. There are significant updates that we're doing actually right now. You haven't seen them as customers today because all of this happens kind of under the hood in the backend, but hopefully latest kind of early Q1, we can turn this on so that you can actually see and feel query responses being much faster. And this continues to be something that is top of mind for us. There are multiple elements to this. Because it depends a little bit on what kind of content you're querying for, as we have multiple different systems running. And let me just say, our big goal is to bring all of those systems together in a much more performant way. I don't want to make this a big architecture call, but I do want to assure you that this is absolutely top of mind for us, and that ultimately we want to make sure that you get to your answer really quickly. And this is something where you can continue to see improvements throughout the next year. The last thing on here is something that I mentioned at the very beginning, significant investments in consolidating content across all of our products. So this is really something that we take very serious. We want to make sure that the content that we have becomes accessible to all of our customers. And step one for us is in PatentSight, you're going to see significantly more patent content by a massive content expansion later in 2023. And this is something where we will work with you to show you also what the difference actually means to some of the metrics, some of the results. This is not going to just be a silent release from one day to another. This is going to take quite a while, and we're looking for a lot of feedback there. But ultimately, it's really about consolidating the underlying content that we have and making sure that no matter which product you are from us, you always have the most up-to-date and accurate information that we have. And again, this is something that we're investing quite a bit in to make sure that we're very, very competitive on having the best content across all of our products. Last but not least, I want to talk about kind of things that I can't show you right now, but that are in the works. One is a better feedback mechanism. We want to hear from you. We want to learn more about the problems that you have. There's multiple things that we're working on right now to make sure that going forward, we have a much more direct communication line to ultimately our customers and understand what works, what doesn't work, what are the things that you need, that you're looking for, because we want to listen, hear, and adapt our priorities accordingly. Other things in PatentSight that we'll always have on top of our mind are new chart types, new visualizations, new capabilities to really crunch data. This is certainly something that you'll see next year. We don't have any specifics on what yet. There are a few prototypes that we have. There's quite a lot of exciting ideas that we will ship, but this is where I don't have a date for you yet. And last but not least, one of the very important things for us is additional company data and identifiers. So this includes everything from classifications, for instance, industry classifications, to more information at the company level directly, so at the ownership information, especially in PatentSight, so that it makes it a lot easier for you to then make industry comparisons, to identify big companies versus small according to certain identifiers that define big and small. So these are a lot of things that where it really is about bringing in kind of additional company level information. And these are all things that we're eager to do next year as well. But I can't share final dates on this yet. But all of these are things that we're actively working on. And let me end this by saying we've just internally made a few changes to really make sure that we can execute a lot of things faster and in parallel, so that all of the things that I've talked about, we can really truly deliver to you next year. So we're very, very excited about the redesign that we've shipped in PatentSight, about the improvements that we've made to underlying systems already. And it's now really time to share all of this with you so that you can actually feel this in your day-to-day as well. And this is something that we're absolutely committed to. So with that, I ran through the deck pretty quickly. I hope any of that was understandable, but I did want to make sure we have time for any questions or discussions or feedback in general.
And just a reminder, everyone, you can utilize the Q&A feature in the Zoom webinar to submit those questions. I know, just as we wait for some questions to come in, I wish there was kind of a celebration firework action that could be in there. I know for the single document level searching in PatentSight is one of the main question that we get pretty frequently. So I would have loved for the panelists to be able to, or the attendees to be able to hit that when that slide came up. So thank you, Jonas, for providing a little bit of insight into that. As I know that is a question that frequently comes up. Also, regarding the litigation, there was a little note on the screen that Jonas had, and he mentioned verbally about, we're looking for feedback on how that information can be very helpful and useful for you. So that is something that either today in the session, if you want to step forward and raise your hand for that, or reach out to your specific either client manager or customer success manager to set up a conversation where we can explore further exactly what are your requirements there, what questions we're trying to answer, how that information could ultimately be leveraged to make to bring some value to the information that you're and deliverables that you're trying to develop. It looks like while we were sitting there talking, one question did come through. We're looking, so this is with a target to emerging companies, but integrated company level information would be most welcome. I wonder for any specific additional details around that on how that could be beneficial, because maybe we could spark a little conversation here on what that is and what is meant by that, or how that could be valuable. from a day-to-day process perspective.
And while we give the chance to give more context to this, we're aware of some of the use cases, but again, if you have specific problems that you're tackling today where you pull data from one system and then you're matching it, maybe with custom fields or with tags or however you do some of those things, we're aware of some of those problems. But if there's specific data points on industries, on ownership that you think we should be adding, please let us know, because we're looking at it from an all-up perspective of what can we match, and if there's specific problems that you have already and specific use cases, we're more than happy to prioritize some of those items.
And this is something that, if not able to share the information, we can have a follow-up conversation, and we'd be happy to provide some further insights based off of that, those detailed parameters, requirements around that. Let's see. Okay, so financial information, we have some clarity here and context, so thank you very much. Financial information, funding,
Yes.
or even commercialized product information or approvals is the context there, Jonas.
Okay, that's very useful. This is actually something that like product information is quite interesting, because some of the litigation cases have product information associated to it. So if you have a patent litigation case, depending on the case itself, there is sometimes a definition of what product this case is actually about. So the end product, not just the patent. And this is interesting information because we can link the litigation case to the patent, and if in the litigation case there's a product definition that we can then infer that back to the patent itself from the litigation case. Obviously, this is not something that will give us widespread product definition to all patents, but something interesting to think about. And then on the financial identifiers, this is certainly something that we're looking into. So just industry, company sizes, revenue, number of employees, all kinds of different metrics there that we're certainly looking into bringing in. These things are sometimes tricky because we need to work with different partners that provide the data, and we have pretty high standards on accuracy there. It's actually not as trivial to make sure that we can get the data that we want to, but certainly something that we'll tackle next year.
Great. And thank you for who submitted that question and the follow-up context on there. I think we'll maybe give another 30 seconds to see if anybody has any other questions to enter into the chat or into the Q&A section for Jonas. Again, just as a reminder, these sessions are going to be made available in the future. Again, and if you have any additional information regarding wanting to partake in any discovery discovery sessions on litigation data or any of the other features that were mentioned today, please reach out to your customer success manager and your client managers, and we can schedule those one-on-one along with the product team.
Absolutely. We would love to talk to you directly and learn from you and make sure that the features that we deliver ultimately make your life easier. This is absolutely front and center of everything that we do. And the more feedback that you can share on use cases and problems that you might run into, the better for us. So we're absolutely here to listen and learn. So thank you so much for taking the time today to listen to me, and hopefully for the opportunity for me to listen to you going forward.
Yes, thank you very much, Jonas, for your time today. For everyone currently attending the webinar, we are going to take an hour-long break here. We will come back at 1:30 Eastern time with our next batch of presentations for the afternoon. So just everyone, thank you very much for a very informative and productive morning, and we look to continue that into the afternoon session. So thank you, and talk to you in an hour. Good afternoon, good morning to everyone that's on the line. Thank you very much for your continued participation and attendance in the session today. We have an afternoon full of a couple more presenters, as well as the weirdest, strangest patent activity that we have. So to kickstart it off, we're gonna, with our afternoon sessions on the East Coast here, we're going to I'm gonna hand it over to Ben Hoops. Ben is a registered patent attorney based out of Boise, Idaho. He is a senior patent counsel at HP with a background in electrical engineering. And Ben's extensive patent preparation and prosecution experience allows him to have an insider take on the monitoring of outside counsel performance, which is what he's going to speak about today. So Ben, thank you very much for joining us today and for spending the time to walk us through the topic that you have here. And just to remind everybody, you can submit your questions during the session in the Q&A. So Ben, I'll turn it over to you. Thank you.
Thanks, Nick, for that introduction, and thank you to everyone for joining. Hopefully this is of general interest to everyone. So what I'm going to do is real briefly provide an overview of how we can use performance monitoring using PatentAdvisor for attorney stats, be it outside counsel or corporations or law firms. So hopping right into there, I do want to start off with this agenda to kind of show everyone the direction that we're heading. Oh yeah, I need to start my video. Thanks for the reminder. So we're going to start off talking about, what is this performance monitoring in general? What is it referring to? I will alternatively use the term benchmarking, and then we'll talk about, why we need to care about this. Why is this important? And after that, I want to hop into kind of a nuts and bolts discussion of how we set this up for personal benchmarking, firm and corporate benchmarking, and then our own portfolio alignment. So with that out of the way, let's go ahead and move to the next slide. So first question, what is performance monitoring? Thinking about PatentAdvisor, we think of examiner trends, examiner stats. Am I saying that we can use this for other purposes? Yes, we can. And so what's interesting is because PatentAdvisor has such a deep trove of file wrapper history and data, we can use it to provide insights into corporate, law firm, attorney data and trends. And so it's really quite interesting. One thing that I do want to highlight here at the outset, and I'm going to dig into this a little bit deeper on the next slide, is just that this is just a data point, of course. And so it's driven by a lot of different factors that we as attorneys don't always have control over. And so we do need to keep that in mind. But what really is interesting about PatentAdvisor is the way that it bucketizes patent examiners based on difficulty. And so we can potentially compare against across a normalized sample set and be able to compare attorney work using PatentAdvisor. And so, again, as I mentioned, I do want to dig into this warning a little bit. I'm offering up myself here as an example of why we need to be careful. And so I've got two different dashboards up. One with some stats. I filtered right at the period after I got out of law school and was a brand new associate. And then on the right, we're looking at my stats while at HP. And so we can see that there are some pretty significant differences here. And so I just like to remind everyone listening that there are so many different variables that could go into these differences. So, on the left-hand side, I was a brand new associate. At that time, most of my build time was spent doing litigation support. And so when I did do patent prep and pros, I was really approaching things like a litigator. I was being very zealous, right? I was fighting everything. The examiner was always wrong. The interpretations were ridiculous. The art was never on point. And that led to a much more combative approach. And as you can tell, lots of office actions until allowance. Then, looking at some of the variables that have led to these HP stats, I am really focused in on a fairly narrow set of subject matter and technology areas. And when I pull up an office action, I'm often going to go into the invention disclosure documents. I'm going to look at potentially what our technical reviewers may have said about why the technology is of importance to the industry. And in contrast, when I was a brand new associate, I was just, digging into the spec, looking at the claims and trying to protect as much as I could. So it's really led to different approaches. And so, there are a number of other variables, like when you're a new associate, you're getting work from a lot of different attorneys, a lot of different clients. It's difficult to get familiar with examiners, whereas when you're working in a fairly constrained set of technology areas, even though I've spanned, PCs to industrial printers and 3D printers at HP, you do tend to get familiar with examiners. You get to know the technology really well. So it leads to the differences that I'm showing. So at HP, apparently my average number of office actions is 1.12 allowance. And part of the reason for that is, as a portfolio manager, when I'm seeing cases coming across, if there are real easy things to take care of, maybe a double patenting rejection is the only thing left in a case, or an ex parte quail action. I may tend to hold on to those and take care of it internally, rather than wanting to send out and have someone bill for that work, just because it's so easy. It's just a couple minutes of my time to get that taken care of. So anyway, that's why we are seeing this difference. And so my message for everyone here, as we talk about these stats and these performance metrics, is that it's important to understand that the data doesn't necessarily convey all of the necessary context to understand what's going on. But that being said, I think it still can be useful. And in this next slide, I'm talking about a use case where I really like using this data to benchmark what's going on. This is part of PatentAdvisor's outside counsel evaluation module. And it can be really nice if we are focusing on a single corporation. So we only have one client calling the shots, right? So there's going to be less variability. And then you can also focus on a single art unit. And so we can really focus in, kind of control as much as it's possible to control, right? A lot of the variables that could affect the data. And so I do want to show how we get there, how we get into this module. On the main PatentAdvisor screen, there is a link to go right into it. And then a little bit later in the presentation, I do show more of the steps as to how we generate this report. So on the right, I'm showing just an excerpt from the report. I'm specifically showing the PatentAdvisor efficiency graph. And so as we look at this, we've got the y-axis, which is showing the allowance rates. And then the x-axis is showing the PatentAdvisor efficiency score. It may be worth talking about this efficiency score a little bit so that we all know what we're looking at. The efficiency score is going to act a lot like the golf scoring system. And so, as I mentioned, we're bucketizing examiners in order to normalize what we're looking at. And using this efficiency scoring system, the average number of office actions until an allowance, or an allowance in this case, is going to be par. And then if we need to make additional office actions, respond to additional office actions, that's going to then be above par. It'll be like a bogey or a double bogey. Or if we are able to get a case allowed more quickly than that average, then it will be, for instance, a birdie or an eagle. And so that's essentially how this efficiency score works. There's a lot going on under the hood, and a lot that I don't necessarily understand. And so my natural question seeing this is, well, does that mean if we just come up with this long picture claim where we are taking a page and a half maybe, and the examiner is just going to rubber stamp that thing because it's so long, that we're going to get an amazing efficiency score? And I don't think that's the case. And the reason that I don't think that's the case is because as I manage my own outside counsel, there are firms for whom I have that intuition that they tend to be a little bit more willing to add more language into the claim amendments. They tend to be a little bit more willing to accept allowable subject matter, even when the rejection is a little bit weak. And in spite of that, those firms weren't as high in the efficiency score or on that axis. And so I'm not sure what else is taken into account, because there is a lot going on there. It's probably the length of amendments that are being made to the claims and stuff like that. But anyway, I just wanted to make sure that was clear, and that's what I had seen in my own practice. But again, like I've said already before, and I'll say many more times before we get to the end, this is just a data point, and we're just using this to help help us make the best professional decisions that we can. Okay, so let's talk about the graph that we have up on the report. What we see is we see 4 different law firms in a single tech area for a single corporation. You can see that we've got firms 1 and firm 2, and I have anonymized these firms to protect the innocent. We can see these first 2 firms are pretty close together. Statistically, there's not much separating them. And then in contrast, we see firm 3 much closer to that par line. Firm 3 is just barely above par. And then we see firm 4 that is below par and appears to be very efficient. I do want to talk a little bit about allowance rate really quickly as an aside. Personally, I don't put too much stock in these allowance rates because it's so hard to control what's going on. It's a lot of internal decision making. So for instance, maybe firm 3, their allowance rate is a little bit lower because they got this portion of a patent portfolio built around this R&D project that was subsequently abandoned. And then maybe so it led to this handful of patent applications that were no longer important for the corporation. And so that's for me why I don't worry too much about the allowance rates, but be aware that it's there. It's a data point. We can allow it to kind of supplement the decision making. So, looking at this chart, how would I use the information? On the surface, my inclination may be to move work from firms 1 and 2 to firms 3 and 4 because they appear to be more efficient. Then the next slide, and I'll go ahead and move there now, we can talk about some other data points that could sway us one way or the other as we're trying to make that decision. So what we see here, I've got a table from that same report. All of these charts and graphs come from that same report. I've got a table that lists those firms in alphabetical order, and again, the names remain the same. And recall that firms 1 and 2 were the ones that were least efficient, and firm 4 was the most efficient. And we can see that there with the overall scores. Anyway, there's a few things that jump out immediately as you look at this table. First of all, there's no red examiners. And I went into PatentAdvisor and I verified. So this art unit is very yellow and green heavy. So there's 14 active examiners, 8 are yellow and 5 are green, and there's only 1 red. So for this set of outside counsel, they have never encountered a red examiner in this art unit. So that's an interesting data point. It's an interesting thing to keep in mind. The next thing that jumps out is, firm 2 here has a really low score with green examiners, and low isn't bad. and this is interesting. We often see this when firms are kind of using a cookie cutter approach to examination. And if we look at it this way, green examiners tend to allow cases at higher rates and with fewer office actions than their yellow and their red counterparts, right? And so if we are constantly, 1 or 2 actions above their average, and if our allowance rate is lower than their average, then at that point we need to take stock and potentially recalibrate what we're doing because it looks like something's not lining up right. So how would I use this information? Looking at this, I may move cases from that firm 2 to potentially firm 3. We can see that firm 3 is actually the most efficient with green examiners. Another option could be to pay closer attention to office actions and recommendations coming across my desk from firm 2 when they're assigned to a green examiner. So that's those are how we could handle that. Another interesting point that comes out of this table is that we see that firm 1 actually tends to be hitting above par, so lots of bogeys with both yellow and green examiners. And so that suggests to me that firm 1 is maybe getting into a habit of taking an extra stroke on each hole. So, this may be an opportunity to sit down and talk strategy with that team. talk about what we're seeing from examiners and how we can maybe eliminate an office action. Alternatively, it could just be an opportunity to move work from firm 1 to firms 3 and 4. So to supplement that table, I've got a bar chart on the upper right, and this bar chart shows the average number of office actions to issuance. This is a really interesting one. You'll remember that in my slide, I had, as a brand new associate, 3.1, something like that, office actions to allowance on average, and then currently it's 1.1, way too low, but it is what it is. Looking here, we see that firm 1 is taking on average 2.5 office actions to get to allowance, and you contrast that with firm 4 that is only taking about 1.5. I think it's just under that, or just over that, excuse me, office actions to allowance on average. And so that means potentially thousands of dollars in cost savings. And so, I did a little bit of math. Don't worry, it's not hard beforehand. But if we assume a $3,000 office action response, 38 applications, an average of 2.5 responses, we're looking at $285,000 for firm 1's work. And in contrast, if we use that same assumption of $3,000 per response and 24 applications and at about 1.5 average, we're looking at $108,000 in legal fees for firm 4. So then we can use those numbers to calculate an average cost per application. So firm 1, we end up with $7,500 to prosecute each one of those applications to allowance on average, while firm 4 on average was only $4,500. So that's a $3,000 savings per application. And you can appreciate that in the aggregate, that's just going to be an enormous savings. But again, we don't want to use this data point blindly, and perhaps we like the work product from firm 1 more than firm 4. Ultimately, this data is about helping us make the best decisions for our clients and move things along in an intelligent manner. And so there's that data point. Another data point that I like using a lot, this is the lower bar chart, and it talks about the number of patent applications with 2 or more RCEs. So I like looking at RCEs. My employer has rules about RCEs and when they're allowed, when they're not allowed. I know many companies do as well. And so you're probably aware that RCEs become more expensive as you go on. A first RCE is, I think, just under $1,400. And then second and subsequent RCEs are up at $2,000 a pop. So it's a lot of money. And looking at this lower bar chart, we see that nearly 1/3 of firm 2's application have required 2 or more RCEs to allowance. And so that means that for those 12 granted patents, an additional at least $2,000 in fees to the USPTO, in addition to the extra fees, just because it was a higher average office actions on average to allowance. So a lot going on there. We can contrast that with firm 4 that only had a single application that required 2 or more RCEs to get to issuance. But even setting aside this cost issue, when I see stats like this, I wonder, is the firm wasting office actions? Are we kind of spinning our wheels and not making progress? And a corollary to that is, are we creating a file wrapper that could come back to haunt us? Multiple office action responses, multiple RCEs. My preference is to get things done quickly and say as little as possible, and I don't think I'm alone with that. So anyway, that's what we're looking at here with these data points and how they may be useful. Again, this is just tip of the iceberg. There's so much fun data in there. I think most people on this call are probably data nerds and enjoy this as much as I do, but there's a lot in there. I'm going to go ahead. I see we got some questions in Q&A. This is probably a good time to pull those up. Does the efficiency score penalize firms for filing RCEs, or does it treat RCEs as the same as any other office action responses?
So
I'm not sure. Nick, do you know the
I'll
answer to
jump
that
in
one?
there, Ben. This is something we are confirming, but the fact that any event is considered the same. So we're not putting extra weight behind the RCEs as opposed to an office action. And that kind of leads into the second question about factoring costs to clients. And that is not something that we are factoring into the efficiency score. It's more about the time length and the number of events that occur. So if events are prolonging ultimately the path to disposition, that is what is going to have the main impact on the efficiency score.
Yeah.
And Ben, I see you have the chat there on the last one. I guess maybe just to take your take on, and for the question for the audience is, what do you recommend if the business decision making of the client leads to a high number of business related abandonments and it crashes your firm number as a result? So I don't know, maybe Ben, you look at this from your previous outside counsel experience, or if you're from the client perspective, if that's something that you would somehow try to uncover or determine as you're looking at the statistics.
Yeah, that's a really good question. One thing that I meant to say and I didn't mention is personally as in-house counsel, I appreciate it when my outside counsel comes to me and we have a frank discussion about whether or not it's worth continuing prosecution of an application. Usually those discussions, in those discussions, the outside counsel brings a lot of legal and practical experience and knowledge into those discussions. And what I'm bringing is the business and the strategy perspective. And so, ultimately, that's why I don't put much weight in the allowance rates, because I think there's a lot that goes into it that is very difficult to control from the outside counsel perspective. And again, I really do appreciate having those frank conversations with my outside counsel. All right, good questions.
Yeah, fantastic. We have a few minutes left. If anybody has any follow-ups to those questions that were just discussed, or if we have any additional questions based off the content.
Yeah.
I think I know one of the questions, Ben, that our team had when we were interested in your topic that was coming was, how do you decide which cases are handled internally and by outside counsel? And that was actually one of the topics, one of the main parts that you had in the beginning. So I guess in case anybody missed that part of the presentation, might be best to maybe, if you wouldn't mind, just revisiting, how you make the distinction between which cases you handle internally versus outside counsel.
I think we are going to see quite a bit of variability in the way different attorneys answer that question, different in-house attorneys. Are we looking at this from the perspective of someone like me who has very low, if any, filing, new application filing metrics or office action response metrics? Maybe I will be more inclined to push things out because I'll have so much else on my plate. So there's a lot that goes into it, and so I think we're going to see a lot of differences across the board. But yeah, for me, another thing that comes to mind is what the fee arrangement is with our outside counsel. If I'm paying a flat fee for everything, and I get a real easy double patenting rejection where I just need to file a terminal disclaimer, that may be one where I just opt to keep that in house. It's a little bit of paralegal time, a little bit of my time, and a pretty big savings for my own client. Yeah, time is going much quicker than I had anticipated. I've got a couple of slides here talking through how we get all this set up. And so the first thing I wanted to cover was this idea of personal benchmarking, how we set that up. So what you want to do is you need to do a file wrapper search, and so you get to that with the search button and then file wrappers. For me, it was just my last name. This file wrapper search does take Boolean operators, so it was my last name and my reg number, and that led to search results. Then there is a little icon, and it looks like this. It's a little cloud icon that shows up, and you export that to a briefcase. And then you can go into the dashboard exploration part, and you can filter on time, on assignee, you can filter on law firm. There are a lot of different ways you can filter. And so it's fun to get in there, play with the data. And really that's my recommendation. If we're going to go out there and put our outside counsel under a microscope, let's do the same thing to ourselves. And hopefully that will help us have a little bit more compassion. Also, it could help us identify our own blind spots and weaknesses. And so it can be real useful. All right, moving on to the next slide. Let's talk about firm or corporation or portfolio benchmarking. This is done a similar way, except we're not starting with the file wrapper search. We're creating a briefcase. And so you do that by going into the My Saved Work. You create that briefcase. PatentAdvisor will ask you to name it, and I've just named the sample briefcase. And then you have to add applications like I show at 3. We have a couple of ways that we can do that. We can actually enter a list into the text field and submit those. Or if you have an IP management system, you may be able to generate a report, an Excel or a CSV spreadsheet, and you can go ahead and drop those in. And then you can go into the same dashboard exploration module and explore things in that way with the same filtering. And then finally, I want to talk about getting the benchmarking report, how we get that up. I mentioned earlier that off of the main page in PatentAdvisor, there is a link for that. Alternatively, you can get to it by the business development button. There's outside counsel evaluation. You can enter the company. PatentAdvisor will ask you to specify based on their ASCII database which ones correspond to your search string. Alternatively, you could actually enter your briefcase, and that may be an easier way to clear out any noise. Next, you're going to have to specify a date range, either by final disposition or filing date, and then you will select the law firms, as I show here at 4. One thing that's worth mentioning here, the last step is to select the tech areas. If you go too broad, then you're introducing a lot of noise, a lot of variability, and so that's why I like focusing in on a particular art unit. So you can really zoom in on that art unit and fairly, or more fairly, compare outside counsel. You hit generate report, and then you're ready to go. So sorry that was so quick. Time just flew. Are there any other questions?
Muting myself there. I do not see anything coming through as of right now, Ben. So I think just maybe give it another 10 seconds to see if anybody puts anything through. But I think that those background information, I know as we were kind of talking offline on what would be valuable to present today, that would be really advantageous for our community here, is like that background talk track behind it. So I really like that color commentary that you put behind, like, what does the data mean, is really what we try to, I think it's a real valuable information, and helps then apply that to other cases. So it's not just one by, well, when I have this scenario or this scenario, you can broadly apply to all different types of scenarios. So I know from my perspective, that was really helpful, and really really helpful and really insightful for when we have our customers asking, well, what should I make it? What type of decisions or conclusions should I draw from this? It's really good to have that insider point of view, especially from someone who's been on both sides of the coin and knows what the ramifications are from this perspective versus that perspective. So very, very invaluable information, Ben. And as always, appreciate your graciousness of extending your time to come and speak on our meetings and our sessions, because I think it's again very invaluable, that perspective. So I guess it looks like that might be it from the Q&A perspective.
Yeah. Well, thank you, Nick. It's a pleasure to chat, and for anyone else online, I'm more than willing to help. So if anyone wants to connect with me and ask more questions, I really enjoy this stuff, and so I'm happy to answer those offline.
Perfect. All right. Well, Ben, thank you very much.
Thanks, everyone.
Enjoy the rest of your afternoon.
Bye.
Okay. And everyone, just a minute. We are gearing up for our next presenter to come online. So just be a minute or two.
All right. Thank you very much. Talk soon.
Everyone, thanks for your patience. Just a quick pivot. We're planning to take a break at the bottom of this half hour. So we're actually going to take our 15-minute break right now. So we will be back at 2:15, and then we'll jump into our next presenter at that time. So thank you everybody for your flexibility. And yeah, we'll be back in 15 minutes. Thank you. Welcome back, everyone. Your break is finished the break right now, and I have the pleasure of introducing Nick Rericha, who is a partner at Dinsmore and Shohl, which is an AmLaw 200 and National Law Journal 250 firm. The firm has also been named to the U.S. News and World Report, as well as Best Lawyers, Best Law Firm lists. Nick focuses his practice on patent preparation and patent prosecution, as well as invalidity and non-infringement opinions. Nick will be demonstrating the drafting workflow tips using PatentOptimizer. And I would like to, again, just like I've extended a thank you to all of our presenters. Nick, thank you very much for your time today and for the quick pivot here on the timing. And we really much appreciate and look forward to your insights from your topic, as all the presentations today have been very insightful and valuable. So Nick, again, thank you very much. And I will hand the floor over to you.
All right. Well, thanks a lot, Nick. I appreciate that introduction and also the opportunity to share a little bit of my knowledge of PatentOptimizer. It's a fantastic product. I really can't live without it. It's one of those things I use almost every day. With that being said, there are so many different features that I don't use, and I hopefully maybe some of the people in the audience at the end can kind of chime in and talk about some of their tips as well. I probably use maybe 10–15% of all the great features, but I think that there's some really good core features that everybody needs to use. And I'm going to walk through some of those as well as some advanced features. And hopefully people in the meeting here will learn something along the way. So I'm going to go ahead and share my screen. And most of this is just going to be a demo of my daily workflow, what I do, how I use the product. So I'm going to share my screen. All right, is that visible for everybody? Nick, can you see that?
Yes, I can.
All right. So when I'm drafting an application, at least with my workflow process, what I do is I first draft the claims. And I actually run PatentOptimizer on the claims before I draft the specification, just because I like to have that good, solid set of claims with correct antecedent basis, spelling, everything kind of good to go and ready for drafting the specification. So this might be a flow that's kind of unique to me, but I think it works. So when I have a good claim set, this is from a LexisNexis sample here. I get into PatentOptimizer and it has my ribbon here with all the different options. I really focus on these guys right here, check parts and check claims. So when I've got a good claim set, I'm ready to check, I'll click check claims. Now you'll notice I get this error message, there's no claim section. So there's really no specification either. So, but to get around that, what I do is I'll just type claims right here, and it knows now that there's going to be a claim set that follows that word claims. So check claims. It's going to say, okay, there's some errors that are detected. And a lot of these errors will be, if you got multiple periods in the claim, so it says claim 3, it's got multiple periods, right? So I'm going to go ahead and fix that. And it should be good to go, fix that error. Now, another thing when you're doing claim checks before a specification, is going to say, hey, I don't have a detailed description. All you got to do is click yes. And then you're into this great window here that provides a lot of information to help you get a good solid set of claims. First thing I like to do is check this claim tree. I make sure that all the numbers flow in order. Sometimes you'll be drafting claims and there'll be something out of order. Maybe claim 11 accidentally depends from claim 1 and you didn't intend for that. So claim 11 then will be up here in this nested part of the tree. So I like to look through, see everything's in order. Looks okay. Then I like to go ahead and check antecedent basis. Now, there's an option here for applying strict antecedent basis logic, or you can deselect that. Now, what this does with strict, even if it's a plural form of an object like anchors or anchor, like it'll flag that. So what I usually do is I usually unclick that. And Now it's going to do it without the strict antecedent basis logic. So it's a little bit more flexible. I want to make sure all my claims have proper antecedent basis. So I'm going to look to see here in this chart or this, this column, where there are no X's, right? So I click that and my goal here then to say, hey, I'm going to get rid of, and it might not be the case that I can, or I think, hey, it's okay. I might make a judgment call. That's a lot of this too is PatentOptimizer. It's a judgment call. It's a tool to help you get comfortable with your claims. So maybe front and rear outlets, there's not strict antecedent basis for it, but I know I've got front outlets and rear outlets. So I'm okay with that. So I'm not going to try to address that. But you can look over here, you click on one of these terms and it'll highlight in red where the issue is. So here you can see I've got claim 1, I've introduced the concrete structure, but claim 3, I'm also introducing the concrete structure. So you can click into it and it'll take you right into the document on where that claim term appears. So I can come down here, oh, it looks like in claim 3, I need to fix that, right? So I'm going to say, said concrete structure. When you come back over here, I click on this top part of the window and it's going to rerun. And then I'm going to come up here and you can see, looks like I still might have an issue with concrete structure. That's because it's appearing up here. But if I made the correction, I'll get the X and I'll be good to go. So in my workflow, I get really comfortable with the claims and then I'll go over to application or to the specification drafting. So I've got a specification here ready to go. Close my claims. All right. And Nick, can you still see my Word window specification? Okay. So from here, now I'm ready to check the claims again. But now what I'm going to do is I'm going to check the claims for support in the specification. So I'm going to click check claims again. I'm going to get my window again and everything should be good to go because I already fixed the antecedent basis before. So now what I'd like to do is focus on the description tab here. This is going to show me, do I have support for all the claim terms in my claims? Anywhere where there's not an X here, I don't have literal support. Now, this is something that where I really like to have an X in all these terms because I don't want, I want to make sure I've got written support for all my claim terms. So I'm going to say, hey, Kate, I've got a body section here, but that's not appearing anywhere in the specification or the detailed description. So I can go in here and try to find, where I'm talking about the body, and maybe I call it something else. So it looks like I haven't discussed it at all. So I can go into the specification and then fix that issue. And then when next time I run it, I'll have an X there. So I'll go through all my claims or through all the terms. And so once I'm really satisfied with my claims, now it's time to check my parts. I want to make sure that all of the parts are named correctly and have the right reference numbers. So go ahead and click check parts.
Nick, this is Nick. I just want to, I hate to stop you for a second, but in the share in Zoom, do you mind sharing your entire screen and not just the Word document? Sure. Because I think it's some of the screens that you're in right now are not being picked up by the
okay.
Zoom meeting.
Yeah, sure.
Yeah, that's okay. Yeah, we were trying to figure out if it was just a delay with the screen or not.
Okay.
But it looks like it's some of this. Yeah, there we go. Perfect. Thank you very much.
Sure. So I'm just going to go back and just show real quick the check claims again. I'll just do a quick high level overview here. So this is what I was talking about before. You got your claim tree. I want to make sure that all my claims are in order. And antecedent basis, what I like to do is sort here. And then I can see, okay, where are my antecedent basis issues? All these that don't have an X, I need to deal with. Either I need to fix it, or I need to say, hey, I'm comfortable with the way that the claim reads. Like, for example, inlet and outlet ends. The claim might say inlet end and outlet end, and you can kind of confirm that by scrolling down and looking for that. So you might make a judgment call and say, hey, that's okay with me. I think that there's proper antecedent basis there. Just to quickly show what I did before, I want to make sure that there's support. So I click the description and I sort it. These are where there's no X's. That's where all the there's no support. So I want to go through each one of these elements and make a judgment call, see if it really does need to be fixed, or if I think it's okay as is. So once I'm comfortable with all that, I know my claims are good to go. So then I'm going to run the check parts, which is right here. So it's going to scan through the document and find the parts. So one thing I've done here is I have linked PatentOptimizer to my drawings. And you can do that by coming over here to figures and clicking. Now this button says change figs, but I forget, it might say link figs or, but anyway, that's the button that you check when you haven't linked or opened the figs yet. So it kind of communicates with your drawings as well as the Word document. So what it can do is it can say, hey, you've got this part number in fig 1, this part number in fig 2, so that you can see, hey, are all my parts actually illustrated in, or do I have all the numbers in the drawings? So I can see here maybe 14 and 16, they're not in the drawings. So I need to go back to the drawings and make sure that I label those parts 14 and 16 correctly. I think that's a really powerful tool. I think we all know how difficult it could be to review drawings, especially when you have a lot of numbered parts. It's easy to miss something. So this is a really great tool to be able to do that. Another thing that I do, this is really important, I make sure that my part numbers are consistent with the part names. What I like to do is I like to try to be as consistent as possible. You'll see the first instance here, it's a bolded, it has bolded font. And then the other instances that follow that don't have the same exact phrasing are not bolded. What I like to do is I like to try to get this list as bold as possible. So I'm really being consistent in my terminology. And sometimes, you can make those judgment calls like prefabricated concrete structure, and you will use concrete structure throughout, which looks like the drafter did here. And maybe that's okay. But it's really great to catch those errors where you're referring to the wrong number of a part name, which I think happens pretty frequently as we're typing and drafting our applications. So really powerful tool. It helps prevent a lot of errors. Another thing you can do is click this find repeated parts. So this will highlight in red, hey, you've used Anchor for 10, but you've also used it for 12. So it's an easy way to kind of look at it and then jump over. And you can click in here, okay, where am I using Anchor? Make the correction so you don't have any red anymore. So again, really powerful tool to correct all those errors that are going to be in the document. Another neat tool here, you can insert part numbers for different terms that appear. So you can click this like Anchor, for example, and it's going to go through the document and it's going to find where you have not used the number for number 10 for Anchor. Now in the abstract, we typically don't have the numbers in, so that's why it's not there. But if you wanted to, you could click insert and it'll insert that part number. I don't use this feature very frequently. I like to manually go in and look and have that control, but it's a feature that's there for you to use. And then you can also kind of do similarly, do insert names, which that's a feature that I don't use frequently. So another great thing here that you can do, especially if you're reviewing somebody else's work, I like to use the windows and kind of draft and use the tool interactively rather than run reports. But if you're reviewing somebody's work or you like to have a nice summary of what's going on, you can run various reports, which is another great tool. So I've opened up the check claims feature here. It brings up my window and you can click report. And these are all the different items that you can include in your report. So I usually just have all of them, more information, the better. So click OK, and it's going to scan through your document and generate that nice report that you can use. So again, I like to use this if I'm reviewing an application that somebody else drafted. I can see all the issues that might be in the document right away in one glance. So we'll let this report run here. It's going through the whole document. Okay. All right, here's the report. It says, hey, here are the errors that you found. Here's that claim 3 with multiple periods. Looks like there's a claim in the specification, so that's a problem. Then you give any nice stuff like word counts, and this is another great feature too that I use. It generates a claim tree for you, and this might be good if you're trying to visualize what your claim set looks like. You can use these tools to get a good view of your claims. Another neat thing here, it also gives you a claim chart, which I think is good, and it highlights all of the elements, which is helpful, especially when you're reviewing somebody else's application. This is a nice format to be able to review. Claims terms not found in the description, and this will give you the same information that where you sort by the description column in the check claims. But here it is in a nice chart. Where are you using the terms in the claims? And here's some phrases not found in the description. Antecedent basis chart, which is great. So really nice report that gives you a good summary of what's going on in the application, as well as the issues that are there. So that's my workflow that I like to do when I'm drafting an application, when I'm reviewing an application, to make sure antecedent basis, written description, parts are correct, all that good stuff. Another great tool that PatentOptimizer has outside of just kind of drafting is the ability to run analytics. And that appears here in this button right here. So I'm going to click that. It'll open up the analytics window. Now, one great tool with analytics is the ability to create really nice claim charts. So you type in your patent here, you can type in multiple numbers, and then you can run the analytics profile. This number here is the sample that we've been working with. So it's going to go find it, and it's going to run its profile. Okay. Here it's giving you a summary of the information, how many claim elements, the reference numbers, the assignees, a lot of good stuff. So if you click over here to profile, you have the option to generate a claim chart. So this might be good, if you're working on opinions, or if you're doing litigation, you need to generate a claim chart to flesh out your positions. Go ahead and click claim chart. What I think is really powerful about this PatentOptimizer's claim chart is you can select the full text for each row, or you can partition it. And I'll show you what that is here once it gets done. You also have the option to do all claims or just the independent claims. show the elements, but I'm going to pick all claims and then partitioned. So you click that and it's going to open it in Excel. And here's your nice claim chart. Now, when you do it you do a partition, it'll break it out into each paragraph gets its own row, which I think is really great. Some other chart generating tools that I've used in the past won't do that, and I manually kind of partition it out myself. So I really like PatentOptimizer for this particular feature. So I can come in and I can make comments on each element or each paragraph, which is a great tool. Another really great feature is when you want to check how has terms been used in your claims. How have they been used by the courts? How are they been interpreted? So for example, you can do that by coming up here and check terms. Click that. And you come over here and you can click all terms. And it'll show you the list of all the terms that appear within the document. So I want to see how has anchor been interpreted by the courts? I want to use this term, but I'm not sure how it's going to be interpreted or if there's any prior history with that. So really great. It shows you, hey, this term, here's a definition of it, but also, it appears in this particular case right here. So if you're drafting an important application and you want to know how is this term going to be interpreted, you can use this tool to see how it's been interpreted by the courts. It's like, here's another one, arcuate. Click into these and it should jump you to the case. It's going to ask me to sign in, but that'll take you to the case itself so that you can do your research there. Another great feature here is the thesaurus. So you can say, okay, what are some other terms that that you can use? I don't use this particular feature that much, but you can see there's some different words that have been associated with arcuate. It looks like some of them aren't really right on point, like segment, but that's a tool that you can kind of play around with to maybe try to come up with a different word if you don't like the current word that you're using. And then here's another great tool called Claims Wizard. So when you're doing I use this tool when I'm drafting a response or I'm doing some claim amendments. So I'm going to come over here and grab this set of claims and open up a new document so I can show you how this works. So if you're like me and you are drafting a claim amendment, you got a lot of amendments. There's some claims, some claims are not amended, and then you accidentally don't do the amendment status correctly, claim status correctly. You miss it. This tool right here is really can help you avoid that problem. So I'm going to do a little amendment here. Let's pretend that I'm drafting a response. So we'll get rid of this. Okay. So you go in here and you get to your PatentOptimizer Claims Wizard, and it gives you all these options. So I like to click Show Claim Amendment Status, get OK. And it should generate a little report for me. I think it went to my my application document, not that other document I opened up before. We'll just let this run for a moment. Okay, we'll close that. So you can run this after you've made all of your amendments, just to do a double check that everything looks good and is proper, especially with your status identifiers. So let this run. Okay, great. So it gives you this nice chart here. So here's my status indicator for claim 1 currently amended. There's a strike through. That's my change that I made. So it captured it correctly. And I have an original. So what you can imagine you can do is you can run this, and if you've got original, but you've got some underline and some strike through, that means that you need to change your status indicator. Which is a great way, other than kind of looking through the claims. Sometimes I know I've missed it before, even after doing a double take. This is a great tool to look at and say, hey, did I get my status indicators right? Do the claims look like I've amended them correctly? Yeah, so another really great tool. And then finally, there's another feature in the claims wizard that you can use that I like. You can kind of mark the claim numbers and the references. So what this does, you can mark each claim so it'll index them. So I'm going to say yes. So it's asking, is this a claim number? And I said yes for all. So it's just going to go through and mark them. Okay. And then what it does is it's going to link the whatever claim is referencing, the reference number. So when this is all done, what you can do is then if you're drafting, you can do a control click, like here on claim 11 where it references claim 9. I could do a control click and it'll take me up to claim 9. So it provides an easy way to navigate your claims, especially when you have a lengthy claim set. So I'll show you how it works. So I'm down here going to claim 8. So boom, I could jump up to claim 8 right away. It really saves the finger from a lot of scrolling. Well, I know when I drafted lengthy claim sets before I started using this feature, I do a lot of scrolling. So again, it's super easy. Control and then click to follow that up. So those are some of the features that I had highlighted. The first, what my workflow is, and then secondly, what are some of the cool features that some people might not know about. I'd like to offer up if anybody else has any features that they like to use that I didn't go over. Like I said, there's a lot of different features available.
Yeah, Nick, I think we have a question here, kind of tying back towards some of the prosecution presentations we've seen. So the question is around, how do some of the features that you went over in your experience and your insight, how do they help kind of downstream in terms of affecting prosecution metrics?
Yeah, that's a great question. So I mean, I think it really helps if you can get a good set of claims without a lot of those problems in them. You know, it'll head off problems in prosecution down the road. So by running the antecedent basis tool, you know, you're not going to get a whole bunch of claim objections down the line. You're going to have a stronger patent. An opposing side, you know, won't have that weapon to say, hey, there's no antecedent basis for this, or there's no written description for this. So if you can head off all those problems on the front end, you've done a great job. And that's why I love this tool, because I feel like I can submit an application that doesn't have any of those problems. And so when I get an office action, it's very rare do I have, you know, 112 rejection. I mean, I'm not saying it doesn't happen, but it definitely does. But you can really head all those off, and it saves the client a lot of time too, because you don't have to deal with those issues when they come up during prosecution. And then the claim amendment tool that I showed, I think that's great, because it'll save time down the road where the examiner doesn't kind of nitpick you on some of those little problems. You know, you claim 3 is marked original, but you know it's amended. So it's just a good way to head off those things.
Perfect. We have one other question that came in. So it says, it asks, have you used the office action template generation component yet to generate a shell?
I have used it. I haven't incorporated that into my workflow yet, but I have used it successfully. I was part of a beta program too with that. I think it works great. It's just not something that I have kind of worked into my workflow yet. But yeah, to the person presenting the question, PatentOptimizer does have a tool, and I can share my screen again. Office action response. So you can use this tool to generate a shell, which can save you a lot of time. So there's quite a bit of features. You can customize it. And the cool thing about this is it's going to go into public pair if you provide your private pair login. I'm not sure how this is working now with Patent Center. I haven't tried it since then, but it'll go and it'll pull all that information and find the rejections and kind of generate that shell for you. So it's a powerful tool.
And just to jump in there, Nick, it is now linked to Patent Center. The naming just hasn't been updated, but it is linked to Patent Center. And one other question in terms of utilizing something in your opinion as well. There's another follow-up question here. Have you used the word track changes conversion tool in the claims wizard, and how do you like it?
I have not actually used that feature. So I think that would be a good for another presenter or somebody else on the line to answer that, because that's, like I said, there are so many features in this tool. It's mind-blowing. So I probably only use 10% of the features, but I think I use them really well. But yeah, I haven't used that particular feature.
For the attendee who asked that question, if you've used it yourself and find like a good way to incorporate it into the workflow and how that makes workflow efficient, or if it answers a couple questions, that'd be great if you could put that back in the Q&A section, and that's something that we can distribute to not only to Nick but also to the rest of the community as well too. Okay, great. Well, Nick, thank you very much for your time today, and we really appreciate you being gracious with walking us through what your workflow looks like, what are some of the challenges that those features address, and yeah, insight into how the tool can provide efficiency as well as value add in your drafts. So again, thank you very much. We're a pleasure to have you. And if there's any follow-up questions, we'll send them to you after the session. Okay.
That's great. Thanks a lot, Nick, and thanks for everybody. I appreciate the opportunity to present on this topic.
Great. Thank you, Nick. Bye. All right. At this point, we are going to pivot over to the contest that I have been mentioning multiple times during the session today. And the reason for that, you'll see, I think we got a good laugh ourselves as a team as these submissions came in on what some of the unique inventions are that are out there. So I'm going to queue up. We have the submissions here on slides. So I'm gonna pull those up and we'll run through them. And then at the end of running through them, we're gonna have a polling question where you can all vote on what you think would be the weirdest or the strangest patent based off of the submissions that we have. So here, let me cue this up. Okay. So again, as I mentioned, this was one that our team internally came up with, that we found that we thought was really, really funny. But we're going to jump into the actual user submissions now. So the first one we have here is actually a amusement park apparatus, a user-operated amusement apparatus for kicking the user's buttocks. So a great title just in and itself makes you chuckle. This was nominated by Anna Wang. And what we have for each of these submissions, you can see not only the patent number, if you want to look this up on your own and use it for a nice little joke in the future, or for maybe something of a similar activity that you might have within your organization in the future. We also have who the inventor was and also the description of the invention as well. Some of these, the title and the picture say it all, but then when you dive into the abstracts, they're just even funnier. So this is one that we're trying to figure out exactly what the game would be around this and ultimately how you win. But I guess that's kind of some of the fun of it. So pay attention to the titles because when we go ahead and launch the poll, that is what you're going to be voting on based off of the titles. So here I'm going to read just quickly the abstract. So this is an amusement apparatus, including a user-operated and controlled apparatus for self-infliction of repeated blows by a plurality of elongated arms, so exactly what the picture is showing, that rotate under user's control. So again, I mean, bonus points for whoever can figure out if this was implemented and if so, how, and do you get a stuffed teddy bear or what it is at the end of it, but really, really funny. So keep this in mind as we go through. Next, we have another user nominated patent here. We have a method of exercising a cat. I think everyone pretty much knows the whole take a flashlight or some flashlight or the red dot and throw it across the room and the cat will follow it all over. Well, someone actually patented that. This was patented by Kevin Tiamis, and this was nominated by Michael Sartori, who actually, if you missed the sessions earlier, he was our first speaker today. And this is a method of inducing cats to exercise by directing a beam of invisible light. So laser pointer, flashlight, whatever it might be. This was actually patented by somebody. Resurrection burial tomb. So someone who's looking to score the fountain of youth, who is or a Lazarus pit, whatever you want to use from a description perspective here. This was nominated by Fred Rosenberger. The drawing is a bit hard to make out exactly what the setup is, but we have the description here. So basically preserving and reviving human beings through a power system and through robotic machine workers. So again, this is looks like back in fairly recent in the 2000s. So who knows, maybe someone will perfect this in 20, 30, 40 years from now. This is something you'll be able to buy off of Amazon. This one we thought was really clever and interesting, and I know as a parent, this would, or even just remembering childhood, this seems like something that should be a product for everybody. Santa Claus detector. the ability to identify through a stocking the signaling of Santa's arrival. There was another picture that was involved that accompanied this, where it was somehow pulled to a string. So if the string is tied to the stocking and then alerts a visual light or a signal based off of pulling that string. This was nominated by Adam Stevenson, and the inventor was Thomas Kane. So maybe this will be the next product that you can bundle with your Elf on the Shelf purchases every year. And then we did have one last submission today that came in. This is contact lenses for animals. This was nominated by Gary Machetta, who is actually going to be speaking in about 45 minutes and presenting on our PatentSight analytics and sustainability. He found this where the contact lens is found to impact the behavior of certain animals by distorting contact lenses. And there, I mean, gives a picture of exactly how that is applied. That must be very difficult to try to get an animal to sit still and do that. So there probably should be a device that goes along with that as well too, to partner with this. So again, just to run through real quick the titles, you guys can go ahead and answer what you think is the weirdest or the strangest. So we have this distorting contact lenses for animals, Santa Claus detector, resurrection burial tomb, method of exercising a cat, and the amusement park game. So we're going to go ahead and launch a polling question. And you guys, everyone has the ability to select one choice and nominate it. And one thing I did want to mention, for all the submissions we received, we are going to make a donation to charity based off of that. So again, thank you for everyone who took the time to research and and identify these patents. We will keep this up for a minute or two and just let everybody vote, and then we'll provide the results. All right, so the results are in. We have here by head and shoulders the apparatus at the amusement park for kicking oneself is by far the top option. So thank you for everyone who partook in that exercise. I hope that was a nice little way to break up the day. And I hope for the ones that did go through and actually find those submissions, I hope that you had fun identifying them. We have 3 more sessions this afternoon. We are going to have another quick tips and tricks from our customer success team. Justin McGill from our team is going to run through, and this is a great segue because we actually just had Nick who went through PatentOptimizer. We're actually going to run through maybe a lesser known feature of PatentOptimizer, which is our online reports tool, where you can do some of the same functions that Nick was just doing, but from the SaaS version. So I'm going to hand it over to Justin at this time.
All right, thank you, Nick. Let me just turn on my camera. All right. Having some technical issues on my end, everyone, but I'm going to share my screen and move forward from here. All right. So as Nick stated, my name is Justin McGill. I'm a customer success manager here at LexisNexis IP. And today we're going to talk about a little known tool within PatentOptimizer, and that's the reports feature. So right now you're just looking at some data I would actually fill into an IDS form. And a lot of folks don't know that there's a quick link right here which will direct us to the online platform. So when you click reports, it will take you to an online menu. It's a quick link. And what we typically use these reports for is really for quick generated reports, such as the summary report, the IDS tool, and in some cases, a term analysis or a claim chart. Now, depending on your, it looks like can everyone see right now? Are you? Okay, you can. Apologies, everyone. But we need to see, not my Word document. I have to do a new share. I apologize. There we go. All right, so hopefully right now you're seeing the online variation of the tool. So after I clicked the globe, this is where it should take you. Now, like I was saying before, depending on the subscription that you have or your firm has, you're going to see different tools here for you. But in most cases, you're going to see the summary report and IDS form. Today, we're just going to run through the summary report, and if we have time, we'll do IDS as well. But just high-level overview here, summary report is essentially everything that could be wrong with your draft, all consolidated into one clean report. And I know that it was briefly mentioned by Nick earlier today. So I'll show you how to create one, and we can quickly run through that as well. Term analysis is really for litigators. So if this is something that your firm is subscribed to, you could look at intrinsic or extrinsic evidence using this online tool. You can create the standard IDS form and then, of course, a claim chart as well. Now, the beauty of this tool is that it's here to get you in and out very quickly. And it does that in 3 different ways. You can either upload a document, you can enter in the text by copying and pasting it in, or if there's an existing document out there, you can add in its citations. And then you'll have this stoplight approach, which essentially will tell you if something's valid, if anything's been changed, or if it's invalid. So that's very helpful. Fun little use case there. I have a lot of folks who like to come here and use citations when generating claim charts of various applications that they pull. Now, I said that you can get in and out very quickly here. And a really cool part of this tool is that you can create more than one report at a time. You could do 4 at a time if you wanted to. Keep in mind, if you're going to do all 4 at once, it could take a few minutes, but you can do it. Today, we'll start with the summary report. So I'm going to upload one of my documents. It could be in Microsoft Word, it could be in PowerPoint as well, or excuse me, PDF. I recommend that you go the Word route just because that's what PatentOptimizer was developed for. And then I'm going to hit open. You're going to notice that it's going to download here at the bottom. And keep in mind too, you actually will get a warning or key indicator saying you can't upload the document if it's open in your Word document. So if your draft is open, make sure it's closed before doing this step. From here, it's just going to confirm if you want to make another report from that, like I said before. So you can either do it at the top or right here. In this case, we'll just stay with the summary report, and then we'll hit next. From here, this is where you're going to configure the summary report. So otherwise saying, let's craft it to exactly what you want. So starting here at the top, you'll select the report configuration. Do you want to have it focus on the claims section or the description section? Or maybe you want to do a full doc analysis, which I think 9 times out of 10 folks want to use. You really have any kind of option here that you want. So we'll stick with the full doc analysis for now. Down here below, you can see the report format. It can be between Microsoft Word or PDF. You can put in the author's name. And if you have a client ID associated with that, you can just delete this and you can put a client ID in. Then below here, I highly recommend you keep the separators for the table contents, the file name, and then adding in some page and line numbers. And don't forget, of course, your drawings. Now, keep in mind, just like PatentOptimizer, this tool works with PDF, Visio, as well as PowerPoint documents. So make sure those are the 3 that you're using when it comes to uploading your figures. Now, what's really cool about this As you can see here, the confirmation that you have a Word file as well as your figures added here to be analyzed. But make sure that everything down here is selected that's relevant to be reviewed by the tool as well. And there's actually one final step which I deliberately skipped on. Maybe you want a little more from this tool. Scroll back up to the top. Right here, hidden below is the advanced settings. Toggle that on, and this is where you can really drill down into what you want from this. So we're doing a full document analysis, so all three are showing up here from your claims, your description, and then including a claim chart as well as a bonus. So if you expand each of these, you'll now see a bunch of different options. So you have a few different claim trees to look at. You can have the tool review unclaimed element-like expressions. I highly recommend over here where the antecedent basis analysis is to toggle strict, because I think in most cases we want the tool to be as strict as possible when identifying those issues. Then down here below, you'll see some more just areas that you can add in. So you can have it analyze your title abstract errors. You can look at the reference post issuance activity. I know a really popular area is missing part numbers as well as inconsistent part labels. These are always called out to me whenever I have sessions with our customers. So definitely have those toggled on if that's something you care about. And then last but not least, you get that bonus claim chart. So if you remember before, you can create claim charts within this tool, but if you're using a summary report, you don't need to create a claim chart because it comes as a bonus if you add it in. And you can even have that drill down to independent claims only or separate list of elements. And as you'll see here, you can keep drilling down into what you want. Now, once you're ready to go, you're going to scroll down to the bottom and you're going to hit next. From here, it's going to confirm everything that we looked at or checked it off before. We wanted it in a PDF, and you can hit this button to go back and edit it, or you could simply come back to number 2 and edit it as well. And if you care about this as well, you can delete user entered data once the report's created. We understand security is everyone's priority, so feel free to toggle that on. Now, I'm going to hit create. And as you can see, I actually generated it before just to save some time because it can take a few minutes. But one thing I want to call out here is that when you're in this section, which is the download section up here at the top right-hand corner, you can access anything that you've created here, but you can also share with a colleague. They don't need PatentOptimizer, which is a really great thing because it's just a standard PDF document. You can download it to your computer, and if it's just something you don't want or for security reasons, you just want to get rid of it, feel free to just hit delete, and then it will be wiped from our system. Now, if you decide to keep it in here, that's perfectly okay. These are secure servers, but they will be wiped out 7 days from when you run the report. All right. Now we're going to take a look at this summary report. Download to your download section, and here you'll be able to see the whole summary report, starting with the title, and then your name, when you pulled it, and copyright information, of course. But if you come to number 2, you'll see the table of contents. Here you can really do a breakdown of things of what you want to look for. So are you looking for claim errors? Or for instance, we can hit that and you can jump from different variations of or different parts of the page that you're looking for. So here you'll see some claim errors. You can see your number of claims, which is very helpful. Word element counts. And then, of course, claim trees. I know that Nick mentioned the claim tree before, where you can identify some claims that might be out of order. So this is really nice that you can come here and you can have it in 3 variations. You can have it in claim tree, you can have it in the bubble diagram, or you can have it in the claim grid. Now, I'm approaching my time, so I'm going to show you some other use cases before my time is up. But we're going to come here to the parts having inconsistent labels. So this is an area where I know a lot of folks worry about when it comes to making sure there's no inconsistencies between your draft and your figures. This is a great place to jump down to, where the summary report will call out the number associated with that name, as well as the location in your draft. So you can go there and you can say, wow, number 10 needs to be merged into anchor positioning insert, for instance. I only have 2 here, but I put a 10 next to number 10, and I put a 10 next to part name insert as well as anchor insert. So you can come in here and just identify those key areas. Another area I'd like to call out, coming back up to the top, is the antecedent basis. errors. So now I know that we all worry about those. So if you come down here, you'll be able to find claim elements lacking proper antecedent basis. So as Nick mentioned before, PatentOptimizer definitely helps out with these 112 errors. And you can see here, starting looking in your claim, you can see highlighted or bolded areas that are creating a either lack of antecedent or an ambiguous antecedent, and then that element name, as well as if it's been addressed in your description or if there's a part number associated with it. So this really gives you a lot when it comes to using the tool. And again, it's very quick. And you can run this in PatentOptimizer as well, but it's just nice in case maybe you're on the go and you want to have something quickly created. And that's how we use a summary report. Oh, and you know what? There was one last thing I wanted to show you. I know that we showed you a claim chart earlier. This is what the claim chart looks like in the summary report. So come down here and you can see the structure of all your claims. So you get a lot here when it comes to using the tool. Now I'm going to go back because I have 5 minutes and just show you how to create an IDS form. Now, I'm going to do a different version of uploading. So you don't need to upload a document. We're just going to copy and paste my information I have here that I just prepared for this demo. And I'm going to copy in the text. Make sure that you name it as well. So we have a bunch of US patents, we have foreign patents, and of course non-patent literature as well. Just make sure that you select IDS form. I skipped step 1. Confirm it down here. And then we're going to hit next. Same deal as before. What kind of report do you want? Do you want to create it in one single IDS form, or do you want separate IDS forms? It's personal preference. Then you can see here selected entries to be reviewed. When it comes to creating an IDS form, you got to give the tool a few minutes typically to analyze everything on the back end using our servers. But once it's done, you're going to have this exclamation point here. Do not panic. It just means you need to confirm some information. So come down below. And then from here, I recommend just selecting everything that you've pasted in there. And you, of course, can show all detected numbers as well as unverified information. And then here's your foreign patents as well. So we're going to grab that. And then, of course, your non-patent literature. Then we're going to hit next. And then just like before, we're just going to hit create, and then you'll have an IDS form created very quickly. And the beauty of this tool, again, is it's not just going to give you a form, it's going to give you a filled out form. And then while this loads, I believe, well, actually, let's just run through this real quick. So this is what your IDS form looks like, and you can create this again in PatentOptimizer. But you can see your US patents, you can see your foreign patents, and then below your non-patent literature. And you're going to see these highlights around there. That means that the tool inputted it for you. And if you ever need to remove a column, you can do it, or row, you can do it up here at the top or at the add another one at the bottom. And that is how we use the online reports tool to create an IDS form as well as a summary report. Now I have 2 minutes for some questions. I know there's some out there. So please let me know and I'll be glad to answer them for you. Thank you.
So we have one question from the audience. Is there a difference between the features of the web version and the software version of PatentOptimizer?
That's a great question. Yes, absolutely. So this is really, the online version is really for quick reports. You know, I've had different firms talk to me about how their strategy of using it. Some use it on the go. I have trained a lot of administration folks on this specific area who want to just run reports for the attorney, so it's not taking away time from them when it comes to drafting. When it comes to PatentOptimizer, and I'm just going to open up my Word, there's a lot when it comes to it. I mean, you have the summary report, IDS form. You can check your terms, check for inconsistencies between your parts and your figures. I mean, this is where you're going to make the changes. The summary report is really just reporting to you what's wrong with your draft. And an IDS form is saving you the time of creating one. While it's putting everything in here. PatentOptimizer is really all about identifying those issues and then making changes quickly so that you efficiently move to prosecution while also simultaneously having a quality draft in hand and ready. Was there another question? All right. All right. Well, thank you everyone for your time. Again, my name is Justin McGill, and I appreciate everyone's time today. Have a great day. And up next, we have Stacy Olkowski. She is a senior product manager here at LexisNexis IP Solutions, and she'll be walking us through LexisNexis PatentAdvisor.
Thanks, Justin. Hi, everybody. I hope you can all hear me. I'm going to do a screen share here, which will cut Justin's screen share off. I hope you don't mind, Justin. And let me blow this up a little bit. I just want to introduce myself. As Justin said, I am the Senior Product Manager for PatentAdvisor. I've been with LexisNexis since May of 2020 and have been making some really great advances in PatentAdvisor, just making sure that the usability of PatentAdvisor, being able to find the data that you need, and getting access to that data as quickly and efficiently as possible is, always top of mind for me. So what I'm going to do today is take you through some of the things that we've updated and upgraded and are from a net new feature inclusion, take you through what those things are. If any part of what I'm talking about sounds interesting to you and you would like to give your opinions about PatentAdvisor, I would love to set up time with anybody that's willing to talk with me, because one big part of my job as a product person is to talk with users. We have a lot of ideas that are brewing for 2023, some super exciting things that we think can help turn your departments, which may be seen as cost centers, into more profit centers. And so I'm going to put it out there that if any of you want to get on a call, give some feedback about some of the ideas that we're developing, I welcome that. And I'm going to make that pitch again at the very end of this presentation. So let me start off by going to just an overview of some of the things that we've done this year. And I'll start there in the upper left-hand corner. I'm going to show you what all of these things look like in case you've missed them, or in case you haven't been in PatentAdvisor in a while. And then I'll do a little bit of a live demo too. I think I can probably just pull over the my browser and share a couple of things live. So first things first, what you'll notice when you go into PatentAdvisor is that there's been a homepage refresh. We did that over the last month or so. We're making adjustments to the various features, making sure that you're able to find all the tools that we have in PatentAdvisor, making sure you realize we do have business development reports. You can benchmark things. There's research tools, and of course our bread and butter, our examiner and art unit statistics. So I'll show you what that looks like in a little bit. We've also done a lot of work this year on what I sort of couch under substantive research. So you may have seen that we have a PTAB decisions search interface that enables you to search for ex parte appeals for issues that are similar to what you're researching, and identifying salient points that you can really use to guide your prosecution strategy. What we've heard and what we understand from you is that you really want to know what's the winning argument that you can make with an examiner. So we are indexing and mining that ex parte appeal those ex parte appeal decisions from PTAB. And so basically helping you apply those arguments that we can mine out of those cases, along the entire path of the prosecution path. So I'll show you what that looks like. That's a really great feature called Argument Finder in our PTAB decisions. I also like to think about PatentAdvisor as giving you data where you need it, right? When you come into PatentAdvisor, there's many options for getting what you need. We've added some really great links on the examiner dashboard that I'll point out, as well as in Quick Pair. And if you have missed it, you can also get all of these examiner analytics directly in Patent Center through our browser extension. I'll show you what that looks like too. That we did roll out last year, but we're going to be putting some new stuff in it in the next couple of months. And so we think that it's probably hands down one of the most helpful tools, because, well, it's helpful if you spend a lot of time in Patent Center or in private pair. If you find yourself in those tools and also needing some examiner and art unit related stats, you'll definitely want to look at our browser extension. And then finally, we've created some enhanced visualizations. So the big one that I'm going to talk about is our Quick Pair timeline. This really gives you an overview, bird's eye view of an application. I'll show you some helpful things within that as well. So first, let's talk about just the homepage refresh. Really, really simple. A nice reminder of how much you can do with PatentAdvisor. Of course, I'm a little bit biased because I know just how much you can do with PatentAdvisor, but I'll first start by just giving you a retro look at what the previous homepage looked like. We realized that there's a lot of links on this page, and some of our reports weren't named as accurately as they possibly could be. So we redesigned this page, and I'm going to point out some of the things that we redesigned by separating all of those great dashboards and the things that you can really get insight from into this insights area that you're going to see there on the left-hand side. And then separating out the file wrappers and PTAB decisions as sort of the substantive research aspects of PatentAdvisor. And finally, we seem to have been getting a lot of questions from users, potentially some of you, asking, do you guys have some business development tools that we can use? I really need to understand how well my firm is performing for me, or I really want to be able to sell my services to a new client or expand, my existing services within my specific client. And so we did some study here and did some research and renamed these tools, brought out the law firm report card, which was sitting under our law firm insights area. And basically just want to showcase the fact that, yes, you can do and create these great reports very, very simply in PatentAdvisor. And, this is one of those things where we have the data to help you make good decisions. We also have the data to help you get business, right? And evaluate the business that you're giving to your firms, right? Depending upon which side you're on, the firm or the corporate side. I do also want to point out, for those of you that have pathways, we renamed that to Tech Center Navigator. Tech Center Navigator is pathways. If you click on that, it will open up pathways and let you do a search the same way. If you don't have pathways or don't know what I'm talking about, that link will not appear on your screen, but that's where that lives now. All right, first thing I'm going to talk about, or the next thing I'm going to talk about, since I just talked through the homepage here, is our Quick Pair timeline. I always like to say that, a visualization, particularly timeline, really helps put things in perspective and gives you a real good sense of just how much work has been done on a particular application and where that application stands today. So this timeline gets updated as soon as there are new events added to the file wrapper. And that's what makes, I think, the Quick Pair timeline extremely helpful. So just to look again back at this a little retroactively, This is the old version of the visualization. It was a very simple visualization, but it didn't have all of the value add that we wanted. You can't get to the documents here. And we wanted to make sure that you were able to not just see everything that's happening here, but get to that next stage. So if you haven't done a quick pair search in a long time, this would be a great time to look up those applications that you're working on currently. Because what we've done with this, with the redesign of this timeline, is integrated a ton more information as well as links. One thing that we heard quite a bit was that, now that I see that there's been, office actions, for example, I have to go look those up in the image file wrapper tab and find them and look for, that particular document, document code, and locate it wherever it might be. Now we've integrated that, so you can see there's links to those PDFs. We'll open up those related documents directly in a new browser window for you. So it's a little bit of a time saver. It's interactive. You can look at the timeline both from a simple version as well as from this extended version. So let me actually pull this over real quick so you can see it live, because I think it's always helpful to see that live. So you should be able to see my screen. I just brought it over. So I'm in this particular application. And if I click over any of these buttons here, this is just our main timeline view. This is where I'm able to get those documents. I can click and it'll pull it up into a new window for me. All right, we did that with office actions. You get both the rejection as well as the response and the claims doc. And then if there is an appeal, we have some of the appeal documents in. We're going to be adding a couple more in the next few weeks. But if you click on appeal, you'll be able to see currently the appeal brief and examiner's answer. And then we'll also be providing a link to the PTAB case too. You'll also notice there's PDFs if you want to see the application, the published application, or the patents itself, the granted patent when it's available. We can get to those directly from here now as well. So it's a nice one-stop shop. Plus, what we've heard, and I'd love to hear from you guys if this has helped you as well, is this is a really great tool to share with your clients. Sometimes they don't understand just how much work you're all doing behind the scenes to get something through prosecution, and so this gives you a real good overview of exactly what's happening and where things might stand. It also does some benchmarking. So we do have the examiner's average time to allowance here, and that's represented down here in this bottom bar. So when you click on it, it does tell you what the estimated approval window is, as well as the average time to allowance. And so that's our quick pair timeline. I'm a big fan, but I'm also definitely somebody who's a little bit biased, having worked on it. Let me know what you think, and let me know if there's additional features you'd want to see in this timeline, if there's additional points on the timeline that are going to be helpful or interesting to you. This is a case right here. Obviously, there's been multiple office actions, an RCE, it's gone to appeal, and it's since issued. It doesn't have an interview here, but if there was an interview, you would also see the interview on this as well. Okay. So next up, let me pull over our next slide here, which is all about PTAB decisions. So we've done a lot of work with PTAB decisions. We brought in the PTAB data last year, and just as a data set, a fabulous data set that really breaks down all of the issues, gives you a really great issue decision tree. But what we wanted to do is really get into the sort of the meat, the text of those documents. And there's a lot of ways, that PTAB cases can help you. And I spell some of them out here, which is a lot to read, and I apologize. So suffice to say that, the way we look at the PTAB decisions, part of PatentAdvisor, is really helping you do strategic research, right? You want to make the best argument for your case. You want to save money early in the process, right? Looking at your examiner's previous PTAB verdicts that were reversed, using those in your responses, making sure that you're looking at this and being able to present the possible outcomes to your clients by giving them the full range of what might happen if you do go to appeal. It's just another way for you to know what your examiner's track record is. And then use that, what's happened to their, during previous appeals, in your current work. We've had some great examples from a couple of practitioners like yourselves who say that they will look at the PTAB cases while they're writing office actions, because they want to use, if there's an argument that they can use from that examiner that's gone up on appeal, they'll use that in their office action. They can, that reference has deemed to be helpful to them in order to make those really great arguments. Now we have this feature called Argument Finder in PTAB. This basically mines arguments and highlights them so you can really see them much easier within the actual cases themselves. So if you open up a particular PTAB case, let's say you're looking at 102 issues, 103 issues in this case, you can scroll through those and it highlights where they are in the case itself. So the idea there being that you might want to use some of that highlighted text within your responses. And I'll show you what that looks like. I'll show you what that looks like live. I'll bring this back over here. So let me go over to, my little menu disappear here for a second. Over to PTAB. So I've just opened up a PTAB case here. You can see that in this particular case, we've got 101, 102, and 103. If I wanted to look at any of these, right, I can scroll through by using these arrows. It just jumps me right down to exactly where, in this case, the 101s are. And I can go through and see all of those particular arguments that are being made. Then, here we go. If I wanted to look at the 102, you can just see how they're highlighted here in red. We try to make it as easy as possible to use it. We know that you guys are strapped for time, and we want to give you that data as quickly as possible, so you can carry on with your work. So the PTAB Decisions Argument Finder is new this year. Let me know if you think that it is helpful. I hope you do, because we certainly think that it's it saves a lot of time in having to not read through those and actually find those specific arguments in those cases. So this is just an example. It blew it up a little bit so you could see all of the ways that we break down all of the issues within Argument Finder. And this is another example of that as well. I showed you the one live, but I like to have backups in case my system goes very slow. I've had some serious computer slowness issues recently. All right, so that's our Argument Finder feature. Again, we tend to think of it as something that's not just for appeals. In fact, I had an attorney say to me, if you're using PTAB decisions just when you're about to get to the appeal stage, you've missed a large portion of the value. And I thought that was really interesting. It sort of backed up the fact that you can use it much earlier in the process. Okay. Now I want to talk a little bit about examiner data and where you can, finding examiner data, various places that we store it within PatentAdvisor and also outside of PatentAdvisor. A couple of things I wanted to point out here. On the examiner dashboard, and some of these things you might have seen already, but since I've got a captive audience today, I figured I would show all of these things all at once. We do have the examiner phone number and email address right on the dashboard. That's for all active examiners, because those are the ones that we can grab from the Department of Commerce. If you've missed it, this is something we added in, which is an interview statistics, giving you the allowance rate with and without interview. Always a great statistic to have sort of armed with as you enter the interview stage. On the examiner dashboard itself, there is a new section called ex parte PTAB decisions. So if you're looking at a particular examiner and you just want to know what cases, what are the PTAB cases that they've been involved in, you can get it right from the examiner dashboard. You can also go to PTAB decisions and grab that. That's not a problem. It's easy enough to do it that way too. But we wanted to really streamline it, figuring if you're searching at, looking at a particular examiner, you want the full picture, and there's a way to get to those PTAB cases from there. And then finally, and this is not just on the examiner dashboard, but this is also in the law firm, the art unit, the assignee dashboards, as we're giving you PDF links out to published apps and grants. So if you click on those, it'll open up those documents in a new window. No need to go to an outside free resource to find those. We have them available. It seemed to make sense that we would want to link them in, save you guys some time from having to go and search for those themselves. So you can now quickly access those published PDFs and grants. And I always say this because I love this feature so much. I think that it's really fabulous. We've had fantastic feedback, probably from many of you about this, but you can get examiner statistics in Patent Center. I mentioned this before. In case you've missed it, we've had a lot of marketing about it. We've talked about it a lot in our webinars. But we do have this browser extension, which is essentially a little piece of code you download. It sits on your browser. You can use it in Chrome and Firefox and in Edge. It sits on your browser. And when you go to Patent Center or Private Pair, you will see examiner data populate on that page. We haven't removed anything from Patent Center, right? All of that data is the same. We've just added in the examiner pieces. So allowance rate, average office actions to allowance, ETA, not just for the examiner, but also for the art unit. And then I have this over here too. So let me pull it over this way and I'll share it again. After you do a search for your application, you can bring it up. This is what Patent Center looks like today, for better or for worse. But with the extension installed, again, it's like 3 clicks. It's very, very simple. I'll turn it on here. You can see we've done a slight bit of design work, trying to make this look a little bit nicer, but then also just pointing out all of the various examiner and art unit stats. So it saves you time. You don't have to go back and look up that examiner within PatentAdvisor. You can get it right here. We bring PatentAdvisor to you, essentially. And then if you do need to go back in, you can search file wrappers or interview stats or appeal stats, or get the application report directly from here too. So always trying to make it a little bit easier, right? Bring the data to you, making sure that, if we can save you time, we know how precious your time is. We want to do that. All right. And so I think, this was really my last slide. I mentioned this at the very beginning and I will say it again. I would love to talk with any of you about PatentAdvisor. I have a lot of projects that I am going through what we call a discovery phase, where I'm trying to get some validation on some of these ideas that I have. So if you're interested in talking with the product team about PatentAdvisor, you want to have a say in our product development, please feel free to contact me and I can send you a link to my calendar. We can set up an easy time to chat And we're all ears. We love talking about this stuff. So with that, I am going to stop
Thank
the
you.
share.
Yeah, Stacy, we actually have one question from the audience.
Yeah.
So we have here, when we filter PTAB decisions using a date range rather than just calendar year, or I guess, can we filter PTAB decisions using a date range rather than just a calendar year? The reason for this is very helpful for doing research that corresponds with the USPTO's fiscal year, which is from September to October, crossing 2 different calendar years.
Yes. Hi, Adam. I know I've thought about this actually. Right now, it's not possible to do that in PTAB decisions. But that is something we can certainly look at for early next year and give you a date range to pick from. I guess my question would be, with something like PTAB decisions, is it okay to just search by months, or would you want to search by a specific date itself? And does it matter? I think that's really the question. So if you want to answer that for me, then it would help, help us with our with what we could implement. But yeah, right now it is just, from a specific date.
So the response, a little context here, dates would be preferable because of turn on times from the USPTO, like the 101 guidance.
Yes. Okay. Got it. Thought that's what you're going to say. Thank you, Adam. And thanks, Nick, for
Of course.
that question. That's great.
I think we have another minute or two. So if anybody else in the audience would like to submit a question or raise a hand if there's a topic that you'd like to discuss with Stacy, please feel free to put that in the chat and we can either answer the question now or take down your contact details. All right. Oh, well, Stacy, thank you so much for running us through some of the features that we have shipped in PatentAdvisor over the recent time frame, and a refresher on some of the features that maybe have shipped a little bit ago, but are still very important to implement into workflows. And if there's again, if anybody submits any follow-up questions or interest, we'll forward that along, your questions and info over to Stacy. So Stacy, thank you very much.
Thanks, Nick. Thanks, everybody. I appreciate it.
Okay. And I'm going to introduce our next presenter. Gary Machetta is Vice President of Intellectual Property at KBR. And he's joining us from Houston, Texas. And as a Philadelphia the Philly fan, I will not hold that against you, Gary, even though we're in a contentious World Series right now. KBR, just a little bit of information about KBR. They deliver science, technology, and engineering solutions to global entities in various markets, including aerospace, defense, industrial, and intelligence. Gary is an experienced legal director, skilled in strategic planning, joint ventures, patent law, and intellectual property. Sustainability is an important topic for KBR, and today Gary is going to walk us through how KBR has implemented United Nations Sustainable Development Goal data utilizing PatentSight, from PatentSight into their analyses. So with that being said, Gary, the floor is yours. Thank you very much for partaking in the session today.
Okay, you can hear me, but trying to share the video here as well.
Yeah, that's okay, Gary. If the video isn't
okay, then that's fine.
Go ahead and
let me go with the screen. Can you see the share screen? More importantly, can you see that? Okay.
Yes, I can, and we can hear you clearly.
Okay, great. So let me get started. I know I'm at the end of the afternoon. Oh, there we go. Let's see if that works. Well,
yep, we can see you too.
You can see me. Okay, all right. So I know we're at the end of the afternoon, and so I'm glad to be able to present to you today. I'm the IP Vice President for KBR, and KBR has been around for more than 100 years. We've really into a lot of different technology areas. We historically more than 100 years as part of our supporting of oil and gas industry, energy and petrochemicals. So we have a lot of IP in those areas. And then we also are in really some new technology areas with quite a broad range from quantum computing all the way to we support NASA and quite a few activities in space and other areas as well. So as far as one of the first challenges, really, and really have to say, I learned so much in terms of the presentations everybody was given here today. And really over the years, I don't know how I've made it without a number of the LexisNexis IP tools. They're just quite valuable. But the first challenge I had in terms of PatentSight, I'll talk quickly about it and then talk about the features as we go. But first challenge was really just trying to convince the different businesses that we needed another tool, because we have a number of analytic tools for us in terms of managing our IP. And so, but I feel that I'm going to talk about one feature really of the PatentSight, just a single one that I feel was really the factor that allowed us to quickly sell this tool internally. And it's been quite a benefit to us within the business here. And so that is the UN SDG data link. So just real quickly, I think most of you know ESG, environmental, social, and government, and corporate governance is the three factors in measuring sustainability. And so we're a Fortune 500 company. I know a number on the call are large companies as well. And so ESG is, I'm going to talk a bit about how important that's continued to become and a focus. And so many are measuring ESG by looking at the SDGs. And these SDGs are the United Nations Sustainable Development Goals, 17 of these, and I'm going to talk more specific. The goals were set up in 2015 and focused to achieve in 2030. So over 100 nations came together and focused on setting up these goals. So just quickly though, what I had to do in terms of convincing the business was I couldn't go into all the detailed analysis in terms of what the tools can do. There is so much PatentSight can do, but really just step back and really at the highest level, looked at again, ESG and UN SDG. Why is it important to the business? And really in the last 2 years, there's been a jump from about 33% of investors focusing on ESG products to 39%. So really trying to get the business mindset that our investors are why we're at KBR to try to focus and provide benefits to our customers as well as our investors here. They're critical. And so as you see here, they're focusing more in terms of the ESG products. We also asked in terms of our financial investors, what part of ESG really is their focus, and 2/3 of them found the environmental extremely important, social and government's about the same, and then another third found somewhat or moderately important. So as you can see, over 90% of the investors were finding that ESG was an important factor to them. Now, something that found in terms of the research as well is a lot of people, there was a misconception that focus on ESG might mean a negative return. And that's really not been the case at all. In fact, about 60% has been saying companies that focus on ESG really are seeing a positive return. Some neutral, but a very small percent in terms of a negative return to the investors. So here's also from an Ernst & Young site, how $23 billion through projects are being invested in terms of these SDG goals worldwide. So just, this was really got the attention in terms of linking to an important goal of KBR and has been for some time. In fact, we've been at KBR doing our sustainability manual that we present as far as here's one of the versions, but since 2017, we've been doing this for our investors. And back then we were been mapping to these United Nations sustainability goals. So it's very important to us. We in fact state within the SDG principles we're firmly aligned with, and we're going to benchmark our sustainability goals with that. So we present this to our shareholders and as part of our corporate and sustainability report. So for those that haven't seen, these are the 17 goals that have been set up. And what LexisNexis did, which is really creative, and I'm not aware of anyone else who's done anything like this, is align these goals then to the patents themselves. So these goals all have specific targets, but these are the specific United Nations goals. And so when I first met with Nicholas and others at LexisNexis, this was the slide that they presented and said, well, PatentSight, this SDG mapping will help you in terms of measurability, transparency, valuation, accessibility. And I have to say that each one of those, it really has helped with KBR. First, in terms of measurability, when presented some of the information to our CFO, he really found it impressive how we can measure, really look at in terms of trying our contribution as KBR to the sustainable world. Also, the transparency. There is a claim many companies are out there talking about what they're doing in terms of ESG initiatives, but this really avoids any type of greenwashing, very, very objective in terms of measurement, and helps us towards a valuation process and making better decisions as a company. And lastly, the accessibility. I think one of the great things about the tool is that it's simple, but it's very, very powerful in terms of what it can do. So here's, if you've used it all, this the PatentSight and the United Nations SDG, this is one of the visualizations that's provided. And inside the circle figure here, it shows the size of in terms of a portfolio and what they're focused on. So they've mapped of the 17, all but 4 of the areas in terms of the SDG goals. So when we took a look at this for KBR, we first saw this and said, you can really dramatically see that really areas 7, 9, and 12, which wasn't a surprise to us because we read some of those areas, those were our patent areas, but we can very much see, for example, renewable energy and fossil fuel technologies have really been a focus for us, the waste management and other areas, and the cybersecurity, smart factories, those pieces as well, really being a big focus, but you see some of the areas here. So it really helped us use this in our strategy and analytics as well. So, but here's what I think in terms of some of the huge benefits that PatentSight and the UN SDG feature here has done for us. First, it speaks the language of the corporation, our investors, and our company in terms of the ESG goals. So this link it wasn't just another analytics tool. This feature itself was very valuable to us. And one of the specific aspects was looking for us in terms of the percentage of patents that are aligned with the UN SDG goals. So we looked at our competitors. We looked at really the trends for the last 20 years. And as we expected, really everyone in the industries we compete in, we're seeing an increase pretty much in terms of more ESG type, more alignment with the SDG goals. And so on average, we were seeing about a 20% 20 years ago, and then nearing 35% creeped up to about 35% as an average for the industry. We kind of did a check on the data as well. There's companies that we feel that are quite sustainable in their initiatives and focus, and they did tend to have the higher percentage alignments, and a few companies in parts of the world with really less ESG focus, we saw much lower in those ranges. We're pleased where KBR had in terms of, we felt we're always a leader in terms of this field, but the data's really supported our arguments with that as well. Another area that really helped us is we're constantly looking at acquisitions. And so as part of these mergers and acquisitions, we've been often saying that it brings in terms of additional support and supporting us in our ESG goals, but here it helps us even measure that. So it was a significant tool in our recent acquisitions and some of our plastic recyclings and other acquisitions that we've done. And then it helps us identify risks, areas that maybe not having patents in place as much. So really a big piece was with our competitive analysis. as we meet with the different businesses and the technical teams. So PatentSight's very valuable for that. But I've had the ask many times now from the businesses, can I talk to the customers about some of this data is so useful in some of the marketing government agencies that as far as KBR and our trends in terms of these areas. So, and then as well with some of our investors. So really found this very valuable, this feature here for us. And then of course, other aspects of the PatentSight was its patent asset index, which again is very valuable, looking at quality versus necessarily quantity of applications and filings, and in our portfolio development monitoring. So as we did our research, we saw other companies that were as well focused on really a percentage of the portfolio aligning to the UN SDG. This is an example with DuPont, where DuPont's goal is 100% innovation in terms of time. Quite aggressive in terms of the number there. We obviously want to focus to a higher number as well over time, but we were pleased to see that other companies that are very much focused in this area are setting their goals and publishing to their investors about their focus and use of this tool as well. So lastly, this was just for public companies are probably well aware of it, but there's ESG disclosure requirements globally that are becoming more and more common. And in fact, the European Union and in the US likely to have additional requirements as far as reporting on ESG type figures. So it is here to stay in terms of the ESG focus. And this tool is really ahead of the game in anything that we've seen as far as can allow us to really show the innovation at KBR and in our industry to our investors, again, to our customers and to our business. It helps me as well to get resources as far as the business to protecting IP when I can show them, look, here's what we've done and here's how it links to our corporate goals. So lastly, I just wanted to really thank Nicholas, Katie, Rebecca, and the whole team there. They've just been so helpful in terms of, there's so much that the tool can do in learning in terms of and applying it to KBR. So I really appreciate that. And again, all the attendees today for attending. I've definitely learned a lot from a number of you there in terms of the presentations. So that's the end of my presentation, but I am open for any questions.
Thank you, Gary. I know sustainability. I myself have presented on that at a couple conferences, and I think it's really moved from a conversation of this is information we should think we need to do something with it to now like actually getting questions and having to take action on it. So I mean, the fact that you're able to put some concrete examples on how it's been beneficial, I think is great for the community here who may be starting to get those initial questions and ultimately then have to provide some type of solutions or answers off of that. So I think that's really insightful from someone who has already had to go through that process to have to share that with everybody. I know you had mentioned that the initially, like, trying to do this before PatentSight, which this has made that a lot easier. Was there any way ahead of time? This is more of a question for some of our firms out there, organizations that might have to try to just on the groundwork try to be able to do this. Were you able to track that beforehand, and if so, maybe in what capacity, from a sustainability perspective for the portfolio?
Sure. I'm not aware of any other tools. Nicholas, I'd be interested what others say with regards to that.
Or was there a way like manually that you would track this and map to yourself? Maybe even in basic Excel sheets. I was just curious if there was actually any methods beforehand to to do this even manually or manual mapping.
Yeah, we did not attempt it because I think it was just very difficult in terms of that. The other group, an important customer of ours, is the U.S. government and governmental agencies, and they're also as well asking about what we're doing in terms of ESG in those areas. So, and they're well aware of these UN SDGs. So this again is a tool we've used even with some of the government agencies to tell them how we've aligned to the UN SDG goals.
Okay. I think there was a question here about you had mentioned the acquisitions. using this to look at M&A due diligence. I guess whatever parameters you can share, like what are some of the aspects and metrics from a sustainability perspective that you take into account? Is that technology related? Is that just the share percentage of the portfolio? How are you leveraging that information?
So really, there's a number of features. You hit on it from a technology standpoint, because as the businesses bring these acquisition, we work closely with them in terms of valuation of what IP portfolio they do have in the area, but also what competitors information is out there. So ties to UNSGG, because there's a planned rollout of an announcement after an acquisition. And so absolutely, that's often something we look at in terms of trying to show that alignment there. And I guess the other thing is the integration and the culture, because if we find a company that maybe does not have these features, we may think twice about the acquisition in terms of that. If there's less filings in certain areas, maybe less focus in terms of IP, but definitely in terms of ESG as well.
Perfect. Let me just take a quick look to see if there's any other questions that came through. I think, Gary, it looks like that is it from the questions from the audience. If anybody would like to, have any further follow-up questions regarding the presentation from Gary today, and also have any just kind of questions on sustainability overall, please feel free to send them in the chat, or even to us, the customer success team offline, and we can funnel those over to Gary. We also, something I'll speak about in a minute, we do have some other sustainable webinars and use cases that we've gone through that can be a point of reference as well too. Examples of like how you can report on this internally and externally. So Gary, always a pleasure to speak with you. Thank you so much for attending the session today, both listening in on some of the sessions that we have from other presenters, and also taking the time to put this together and share this with the rest of the user group.
Thanks for inviting me. Thank you.
Thank you, Gary. Okay. So I just want to quickly point out, as I just mentioned, that we do have on our marketing webpage that you can see here various resources for either webinars that are coming up in the future or webinars that we have completed in the past. A lot of these webinars, they're split. There are actually involving our community users who are either introducing and speaking to a specific topic of theirs, or being included as a panel discussion, as well as our internal customer success team and our product directors and managers being involved as well too. So this is a resource that you have, that you can go to reference these webinars on demand, or flag yourself for what is coming up. I know we have one next week looking at business development from a prosecution perspective, which was discussed from both sides of the coin today, both from outside counsel as well as a corporate perspective as well too. But there are other ones regarding our sustainability, as well as innovation momentum reports, and even trends in patent prosecution as well too. So just want to make sure everybody has that as a resource to keep made aware of on what, because that is one vehicle, as opposed to this this user session that we have, that we will, the hope is to do this on an annual basis. But these are the incrementally, as we go through the year, ways that we can share how our users are leveraging the technology, as well as the innovative ideas that they're coming up with to develop out their workflows. So with that being said, I want to thank everybody today, everyone who attended the session today, all the presenters that dedicated their time to developing out the presentations and spending their time to actually present to everyone today. And also for the users throughout the year that we've heard that this was going to be a valuable forum for us to actually look into scheduling and executing on, as again, really great feedback to hear that this would be the resources that are valuable that help make your jobs more efficient, as well as provide you ideas that you can bring to your organization. So I want to thank everybody, all of our customers that partook, as well as also all of our internal teams, our leadership team, our product team, our customer success team, our client managers, our sales team, everyone that was involved in the organization that was involved to execute this. So thank you, everyone. As I mentioned, there will be a recording of this, as well as the other user meetings that we have done in our other regions. Those will be in the future. They will all be put onto our marketing page where those webinars are. So again, thank you, everyone. And this is a resource that you can refer back to in the future. So enjoy the rest of your afternoons, evenings, depending on what time zones you're in. And thank you again. Goodbye.